We are now going to go back to our formal agenda for today. We have a rather large schedule of matters, so let's get started with the first item.
Oh, he bumped it. It's okay.
Docket number 2024-034, cause number 132-41. In the matter of the request for agency action of Oventive USA, Inc. for an order pooling interests, including the compulsory pooling of interests of certain non-consenting owners in the Wakefield, Utah 1-6, 4-1-6-7-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 6 and 7, 4 South, 1 West, USM, Shane County, Utah. And I believe this was a hearing examiner docket. Mr. Mayo, would you like to begin?
Yeah, Madam Chair, thank you. Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, Oventive USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Mike Begley, Assistant AG, Counsel to Mr. John Baza, the board-directed hearing examiner in this matter.
Okay.
Mr. Baza, would you introduce yourself?
John Baza. I was the board-designated hearing examiner for this matter.
Thank you. Mr. Mayo.
You know, we had a great hearing examiner. It was nice to have Mr. Baza back in the building and did a fantastic job, but I think it's probably appropriate for me to turn it over to him for his recommendation unless the board would like something else. Before I do that, there's probably two housekeeping items I should mention related to exhibits. First, as is customary, we mail out these pleadings and file the proofs of service, the proof that we've mailed these and they've been accepted or not accepted. Through oversight, that wasn't filed prior to the hearing examiner hearing, and so we weren't able to admit those into evidence during the hearing examiner hearing. So I'd like to note for the board that those have been filed, that exhibit regarding proofs of service, and I'd like to essentially ask that the board admit those into evidence in this cause to the extent necessary. Similarly, we use declaration testimony in this hearing examiner process. And those were not labeled as exhibits. Although those were considered and are a part of the record, out of an abundance of caution, I'd ask the board to accept those, admit those into evidence as well as exhibits. The declaration of Peter Burns and Miss Caitlin Heiken.
I think that's fine. So accepted. We will admit them. Mr. Baza.
Thank you, Chairperson Garrison, and I appreciate being in front of this Board of Oil, Gas, and Mining again. My name is John Baza, as I mentioned before. I was the designated hearing examiner for this matter and for the next one that we'll be hearing. As you all know, I retired from my position in Utah State Government near the end of last year, and maybe just as a comment on what has happened since, I've been busy. Retirement is busier than I expected, and I did want this board to know, and I probably could have mentioned this during your public participation at the briefing session, but I was recently appointed by the governor to the Board of Trustees for the School and Institutional Trust Lands Board. That position will start up in July. So things are getting busier than I expected. So I hope that I can still serve this board and conduct these matters from time to time, but we'll have to make sure that my time allotment is dedicated to the right places. Let me go ahead and proceed with the matter at hand. The hearing examiner proceeding in this matter, docket number 2024-034, was conducted on Wednesday, June 19th of 2024. The proceeding was held with an anchor position in the Department of Natural Resources position in Salt Lake City, Utah, and was streamed live on YouTube. No member of the public nor any party opposed the request for agency action from Ovintiv. During the proceeding, various exhibits were admitted into evidence, including declarations from the witnesses that Ovintiv provided who were participated electronically. The Division of Oil, Gas, and Mining and myself had the opportunity to question the witnesses and cross-examine them on behalf of the witnesses of Ovintiv. After reviewing the request for agency action and the admitted exhibits and hearing the testimony presented at the hearing, I found and recommend the following, which is included in the proposed findings of fact and conclusions and draft order that has been presented to the board and filed yesterday. First of all, Ovintiv provided sufficient and adequate notice of opportunity to the parties that it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to provide or to timely participate and should therefore be considered non-consenting parties. The proposed joint operating agreement includes terms that are just and reasonable, and it should therefore be adopted to govern future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. Ovintiv met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Ovintiv prepared proposed findings of fact, conclusions of law, and an order granting its request for agency action. Both the division and I reviewed and after some small edits approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant yesterday. It should now be ready for the board's review and execution. That concludes my presentation to the board this morning, and I leave myself open for questions from the board and any other discussion this morning.
Thank you. Division, do you have any comments?
No substantive comments. Just again, thank you to Mr. Baza, and we appreciated the board, the hearing examiner proceeding and the way it was run, and appreciative of the effort that Mr. Mayo put in as well.
Thank you.
Thank you.
Mr. Mayo, do you have any questions or comments?
None. I don't want to put my witness on the spot, but I'd just like to let the board know we had a new reservoir engineer witness, Miss Caitlin Hyken, who was qualified as an expert for Ovintiv here today. Just thought I'd let the board know in case you see her around in the future at hearings.
Thank you.
Yep.
Board, do you have any comments?
So I probably could have dug this out of the exhibits, but what was the total unleased or unlocatable percentage,
Keep it.
roughly?
I know that it was less than 10%, much less than 10%. I think it was on the order of single-digit percentages. Mr. Mayo may know off the top of his head.
It's probably okay to ask Mr. Burns. Can you hear us okay?
You want to pin him
Yes, I can hear you.
Okay.
in pin 10?
Hey, Matt, IT, it sounds like maybe one of the microphones is on.
Okay. I think it is.
Okay. All right. Sorry, Mr. Burns. Can you hear me okay?
Yes, can you hear me?
Yeah. Hey, I don't know if you heard Board Member Moon's question about the percent that you're pooling in this from the working interest summary. Can you quickly tell Mr. Moon what that is?
Yes, it's just over 0.1%, about 0.124%.
Okay. Thank you for that.
Do we have any other questions from the board? Are we ready to accept? Do we need to vote on this? Could I have a motion to accept Mr. Boz's findings?
I would move that we accept hearing examiner's findings.
A second? All in favor, please say aye.
Aye.
Any opposed? The matter passes, and we will sign the order. Thank you. Very good. We are now going to move on to the next matter, which is docket number 2024-035, cause number 132-42, in the matter of the request for agency action of Oventive USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Taylor, Utah 16-7, 4-2-18-30-1HX well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 18, 19, and 30, 4 South, 2 West, USM, Duchesne County, Utah. Mr. Mayo.
Thank you, Madam Chair. Mitch Mayo, again, of Lear & Lear PLLC, on behalf of the petitioner, Oventive USA, Inc.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Mike Begley, Assistant AG, counsel to Mr. John Baza.
John Baza, the designated hearing examiner in this matter.
Thank you. Mr. Mayo.
Thank you. Before I turn the time over to Mr. Baza to announce his recommended order, a couple housekeeping items again, as with the last one. I'd like to ask the board to admit into evidence both Exhibit 51, the proofs of service, and the declarations that were submitted and utilized for testimony. The declaration of, the substitute declaration of Ashley Ellison and the declaration of Caitlin Heiken.
Any objections? So admitted.
Thank you. And with that, I think it's appropriate to turn it over to the hearing examiner.
Thank you. Mr. Baza.
Thank you again, John Baza, designated hearing examiner in this matter. I'm going to repeat much of what was said for the previous matter, and you'll hear a lot of duplication and redundancy, but that's the nature of these matters, I'm afraid. So a hearing examiner proceeding was conducted in this matter on Wednesday, June 19th, 2024. Proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah, and was streamed live at the same time. No member of the public nor any party opposed the request for agency action. During the proceeding, various exhibits were admitted into evidence, and as Mr. Mayo indicated, we also received declarations from the witnesses who were present for Oventive. They were electronically present and testified from their positions, I believe, wherever they were located. The Division of Oil, Gas, and Mining had the opportunity, as well as I, to cross-examine and question the witnesses, and it was an excellent proceeding, frankly. After reviewing the request for agency action and admitted exhibits and hearing the testimony presented at the hearing, I found and recommend the following. Oventive provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed joint operating agreement includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend the 300% non-consent penalty be imposed as requested. Ovintiv met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Ovintiv prepared the proposed findings of fact, conclusions of law, and an order to grant the request for agency action. Both the division and I reviewed, and after some minimal edits, approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant yesterday afternoon. It should now be ready for the board's review and execution. One small comment I'd like to make on this, and I probably should have said it in the previous matter, there's a great deal of credit that goes to Mr. Mayo, to the division staff, the division's attorneys, for the conduct of this proceeding and for the smooth way it occurred. There's always last-minute things that occur, and as Mr. Mayo can comment on if he wants to, that included the substitute declaration from one of his witnesses. These things happen, we adapt to them, we adjust to them, and I think it was done very well in this matter. So I just wanted to say thank you to all involved for the smooth way this occurred.
Thank you. Appreciate your comments. Division, do you have any comments?
No additional comments to Mr. Bozza's report.
Mr. Mayo?
None from me. Thank you.
Board, do you have any questions or concerns? Could I have a motion to accept the examiner's request?
I'll make a motion to recommend the board approve the findings of the hearing examiner.
I second.
Selma Sierra seconded. All those in favor, please say aye.
Aye.
Any opposed? Please note it was unanimous. Thank you very much, Mr. Bozza. Appreciate your service. Our next docket item, Our next docket item is number 2024-022, cause number 139-174, in the matter of request for agency action of Dean Carlisle Shimon Trust requiring an accounting and payment of royalties against Winds Exploration and Production, LLC. Do we have any participants here? Hello there. Could I? Yeah.
I'll learn all this high-tech stuff.
Could I please have you introduce yourself?
Sure. My name is Heidi Shimon, and I am the trustee for the Dean Carlisle Shimon Trust. We hold lease agreements with Winds Exploration and Production, LLC.
Could I have you speak up just a little bit?
Yes. Sorry, I thought I was talking too loud. Sorry
Thank
about
you.
that.
Go
Do you
ahead.
want me to start? Oh, I'm sorry. I'm Heidi Shimon, and I am the trustee for the Dean Carlisle Shimon Trust. I'm here to represent them in the matter again with Winds Exploration, LLC.
Do you have counsel?
No.
Okay. Please proceed.
Okay. We have agreements with Winds LLC. They are the successor in the lease agreement that was filed as an exhibit with our petition to the board and to the division. We had requested as the mineral owner and that we petitioned because Winds has failed to supply us with payments for royalties, of which have been determined in an audit by the division that those royalties should be paid, and Winds should abide by the terms of our agreement, as well as the statutes and laws outlined in our petition. we request the board a hearing in order to determine why they're not still paying after we have sent numerous notifications to them. In February, we sent a demand letter asking for reasons why they had not paid the obligations that they are required to do so. They have not reported those to us, and they have not responded to our request or the division's request to provide an accounting of why they have not paid and the discrepancies that have been determined in those reportings. Under the code, Utah Code 40-6-9 requires oil and gas operators to make payments of oil and gas proceeds to any person legally entitled within 30 days of sales. And per our agreement with WINS, that is a valid lease. Under the code of 40-6-93A requires that an operator place funds in escrow while determining who is legally entitled to the royalties. As of date, we have not received any agreement, written or verbal, that has occurred, nor have we, there has not been a title suspense letter by a member of the Utah State Bar presented to us suspending their payment, nor is there evidence that royalty funds are being held in an escrow. The payments have been very sporadic. Most oftentimes, instead of the 30 days after production is reported, we are ending up with payments that are 2, 3, and sometimes 4 months past when they should have been paid. It has been my attempt to work with WINS on a monthly basis to determine why there has been no response. It has now been since December of 2023 that the trust has not received any communication from WINS. I think the board is as much alarmed as I am as to why is there no communication from them. The lease that we have with them is in the second term, which requires production of oil and gas in paying quantities and payments of royalties. The trust also has not received shut-in payments nor royalty payments, and there are documented discrepancies between what's been reported to the state and what's actually been reported to the trust. We are petitioning to the board that they hear the findings of Brittany Wallace, who is the auditor that was assigned at the division to conduct her findings. Brittany?
Can I interrupt you for just a second?
Sure.
We have in our packet of information a motion to dismiss. Do you still plan to move forward, or I mean, we have this existing motion out there also. What are your plans going forward before we go any further?
Sure. I'm in the process of retaining legal counsel to help should the case be determined by the board today that it needs to go to a formal hearing. We would prefer if WINS would come and work with us. We would prefer to settle the matters outside of a hearing. But as of date, and in Brittany's reporting, WINS has been uncooperative in supplying the accounting that has been requested of them. We have also requested it from them with no answer. And so thus, if it's determined that WINS is not willing to work with us according to our agreements, then we would pursue forward.
Okay, today's meeting is not the formal hearing of this matter.
Correct.
It's our goal today to determine whether it should be dismissed or move forward to a formal hearing. So before we hear any additional testimony from the division, we probably should make a decision on the board on how we want to move forward. And to that end, I think we should deliberate for just a few minutes, if we could.
Madam Chair, do you want the division's report before you do that?
Yes.
Okay. If you would allow us just a few minutes to present our report to you. Madam Chair.
You have the written report?
Yes.
Okay.
Madam Chair and members of the board, we're here today based on the request for agency action filed by the Shimmons Trust. They filed that request on March 11, 2024. The Dean Carlisle Shimmons Trust filed a request in which it was indicated that they own interest in Carbon County, Utah, and they're subject to an oil and gas lease that is held by production and several producing wells operated by Winds Exploration Production, LLC. Their request indicated that they had not received regular checks since the summer of 2023 and had not received a valid reason as to why those proceeds were not being paid. They requested a hearing before the board and to determine why Winds was not paying the proceeds, and a request for an accounting from Winds as well as the imposition of possible penalties. Pursuant to this request, the board set the matter for investigation negotiation by the division on April 10th, 2024. Ms. Brittany Wallace, an auditor with the division, was assigned to investigate this matter and engage in negotiations with the petitioner and Winds regarding the subject production payments. The investigation negotiation was to be completed by June 10th, 2024. Ms. Wallace submitted her report in a timely manner, which was filed with the board via a division memorandum. As indicated in Ms. Wallace's report, it is estimated that the trust is owed approximately $1,180.19 in unpaid royalties for the months indicated as unpaid by the trust. However, due to a lack of communication with Winds, the division was unable to confirm with Winds that the royalties were not paid for these months, nor were they able to mediate an agreement between the parties to resolve the purported unpaid royalties. So based on Ms. Wallace's investigation, pursuant to Utah Code 40-6-9, subsection 5, and based on the actions of the parties, it is the division's recommendation that this matter be set for a hearing pursuant to Utah Code 40-6-9, subsection 6, to determine why petitioners' proceeds have not been paid, and if unpaid proceeds have been placed in an escrow account pursuant to Utah Code 40-6-9, subsection 3B. So with that in mind, that is the division's recommendation. We also have with me today Ms. Wallace, and as well as Mr. Randy Thacker, who's also auditor for the division. So if you had any questions that you would like to ask them about their report prior to deliberation, they're available.
Ms. Yara?
Just a quick question on your investigation. Is Winds paying royalty to the state but not to the trust
I believe Winds is not paying
at all?
at all.
Okay.
Ms. Gordon?
I'm sorry, could you restate the estimate of unpaid proceeds?
$1,180.19.
Thank you.
Or do you have any other questions? Mr. Wallace?
Yes, in addition to the trust, is it likely that other parties are also not being paid by Wind, and that this is actually a bigger matter?
I can't speak to other specific parties. No one's filed anything. We did get a comment letter from State Lands, from SITLA, indicating that they had some leases that production payments had not been paid on. I have not heard a follow-up with them if there's been any resolution to that. And I'm not sure if anyone from SITLA is here today.
So it sounds like the trust, SITLA, or State Land, or Trust Lands Authority, and the state are all due royalties that have not been paid by Winds?
Again, I can't speak to exactly what Winds has done to other parties because we received a comment letter saying that they were behind on payments. That was filed a few months ago. I don't know the current status of that. Our report found that based on the months that the trust had indicated they were not paid, that is the amount they are owed. We were unable to confirm with Winds if they believe payments were made or anything along that lines. So at this point, our report is based on the information the trust has given us, those amounts have not been paid at that time.
Mr. Church?
Does it appear that production is being reported in a timely manner by when?
I believe that the production has been reported, but we haven't received any information in the last few months. So they haven't reported production probably since January of 24. They've kind of just stopped doing business. To my knowledge, he's in another country, and he's determining if this is a viable asset. That was his words. So,
Are the wells producing today?
no, I believe that the wells are not producing and that there's some maintenance issues. I don't even think there's electricity at the location.
Okay, do you know when they stopped producing? Like, so is this $1,000 kind of the tail end of, or is there more production that's unpaid?
I believe that they've reported all of their production, but it did stop in, the last time it was reported was January of 24.
Okay.
So
So since then, the wells have not been producing?
I believe so, but I can't confirm.
Mr. Borden, did you have a question?
I was actually going to ask about production as well, so.
Go ahead, Randy.
Excuse me. The field has the necessity of having a water injection well. And my understanding is there was a problem with the line, or there's a problem with the well. So they had to shut the well in, therefore they shut the field in. And the details behind that, we did not get that much information. The one time we did talk with the president of WINS, he was not very forthcoming with a lot of information for us. But the field is definitely dependent on that injection well to operate.
Do they have a U.S. address? You mentioned he's out of the country, but do they have a U.S. office?
They say that they have a U.S. office, but I did send 2 certified letters to their Cypress and their Houston location, and I received return mail from both of them.
If I could say something as
Do they
well.
have any other production anywhere else, or is this it?
To our knowledge, this is it.
Okay.
I was just going to confirm with Brittany that when we sent our demand letter on February 14th of 2024, it was unresponsive at that current address. They did have a previous address prior to January, located in Houston, but that address has not been determined as whether WIN's office location is there any longer or not.
Mr. Borden?
How many wells are in this field? Roughly.
It seems like there's 5 or 6 that we're producing, but there's several that are shut in, or some are shut in and some are plugged and abandoned. So the few that were shut in have not operated for a long time.
And is there adequate bonding on these wells, just out of curiosity?
I don't know what the bonding currently is. I would assume that the bonding was carryover from the previous.
The board doesn't mind. We have Joshua Payne. He's more familiar with these operations. Would you like him to answer some of these questions?
Morning, Madam Chair, members of the board. My name is Josh Payne. I'm the compliance manager for the division. Just to answer some of those questions, we've been pursuing WINS for some other compliance-related issues. We've exhausted all our channels as far as finding their address, delivering things via certified mail according to rule and policy. They are indeed unresponsive. And I have a letter in my packet here that I was hoping they would show up that I could hand deliver, but there's a letter from CITLA that they do to go back to the lease question. SITLA has terminated leases based on the lack of production and lack of royalty payment. As far as the last question that was asked, as far as the bonding amounts, more than likely we're going to be under bonded for when these, I'd say in speculation that they will go to orphan just because WINS is being completely unresponsive. Any of their offices that were here based in the U.S. are no longer accepting mail. Again, speculation is that they've gone back to Nigeria, which is where their base is out of. And again, we've exhausted all avenues as far as trying to reach and work with WINS in these matters, in addition to the royalty matter.
Do you have any idea how many unplugged wells there are?
I don't. I would be guessing if I were to tell you right now, but
What
I
is
could
this
definitely
field?
go back and get.
Where are they located?
So the ones that I've been dealing with are out in Carbon County, I believe. Again, without going and making sure, that's just the best of my memory.
Okay.
And there's 2 wells associated with that. They do have some federal wells, but as far as the state's concerned, we've got 2 that will definitely be on the up and coming request for agency action.
Thank you. Ms. Sierra?
Do we have any record of what the production was before they abandoned this field? Was it a high productive place, or was it just marginal?
Again, what Mr. Thackeray pointed out is that their production is based on their injection wells or well, and which one of these injection wells did have issues. It was shut in, it was leaking at site, had some off-site stuff on the SITLA land, which we've been in works with SITLA in that matter. As far as production, I would speculate based on what I recall that they weren't great producers. Again, I could pull that information up, but I don't have the exact numbers at hand.
Does the Schimmon Trust have interest? It's this one lease. Do you have interest anywhere else in the basin?
No,
This is the extent of your mineral interest.
Yes.
Thank you.
Yeah.
Board, any more questions? We're going to step out for just, did I hear a, Mr. Walker?
Yeah, do you have an idea of how much time it's going to be to prepare for a next proceeding?
I think investors would probably want to hear.
If we have a next proceeding?
Are you talking about the division's preparation, or
all parties, I guess?
I mean, the next proceeding would be essentially, if WINS were to show up, really trying to get a determination of why royalties have not been paid, because at this point we have not had that questions answered. Most of our preparation on the division side is done. That would then be really a presentation by WINS of why, or the trust legal counsel as to what penalties they were seeking, if that helps.
I mean, is that 6 months away? Is it 3 months away?
Do you say you're in the process of getting legal counsel?
Yeah.
Do you know how? Do you have any anticipation on when you may retain legal counsel?
Yeah, it'll be within the next 30 days or less. We're working right now.
I couldn't imagine. I mean that would be up to those parties how long they would need.
Yeah.
Honestly, on the division side, I can't speak to that.
Yeah. In light of the findings, I'm sorry, tell me your name again, I'm sorry.
Josh Payne.
Josh.
When you speak,
Oh.
just need to speak a little closer.
Sorry. In light of what Josh has indicated, that they have been unresponsive on their end, it may be in the best interest of the trust to withdraw going for a hearing due to the amounts that it's so low. I did have previous counsel on that, but it was not until we determined Brittany's findings. Our records had indicated different in amountings, but after their thorough accounting and auditing of that, because the amount is only $1,000, I don't think it would be in the best interest at this point, especially where WINS, both members of their organization have left the country, that it's something that unfortunately that I think the trust is just going to have to terminate our lease with Winds and move on.
So you're thinking now is you want to withdraw?
I think in light of the information that has been presented and helped me to determine that there is
Okay.
no longer a company existing as such that we would be able to recover, and also due to the minimal amounts, the legal fees would be exorbitant in comparison of what we could recoup. There are other damages and things that are pending with the 7th District Court that we have filed for and received judgment on. So it may be in the best interest of the trust at this point not to pursue the royalties here and to just move forward with terminating our lease agreements with Winds.
So I guess the question is, can we allow them to withdraw this? Is this without prejudice, or do I need to? Council says we should maybe talk about this so we get it all correct on the record. If you could excuse us for maybe 10 minutes.
Sure.
Just to visit and make sure we get this correct.
Yes.
Thank you.
Can I ask one last question?
Sure.
Go ahead.
Sorry, is there any imminent risk of contaminant release or, gases or liquids from any of these
So
wells?
right now, we did have, like I mentioned before, there was a leak on their injection well. That has since been secured before Winds became unresponsive. To my best knowledge, according to our inspections by our field inspectors, is that everything is secure and that there's no immediate damage. If there were, we'll address that from the compliance standpoint and get that taken care of.
Great, thank you.
We are going off the record. We're going off the record. We'll be back in about 10 minutes. Thank you. Thank you. We're back on the record. I believe we have a motion on this matter.
I move that we deny the motion to dismiss this request for agency action and recognize the withdrawal that we just heard without prejudice.
Board, do I have a second?
I'll second.
Any discussion?
Yeah, I know we're dismissing this, but I expect in the not too distant future we may be hearing from the division on forfeiture of bonds to take care of these wells if they are truly abandoned.
Yes, that's in the process.
Thank you.
Could I have a vote, please? All those in favor?
Aye.
Aye.
Any opposed? Passes unanimously. Thank you. Thank you for your time. I hope it's a equitable resolution for you. And good luck with your endeavors. Thank you. Okay.
Just a short and sweet one.
Yeah.
So it's on the record.
Yeah. Mr. McDonald, will you let me know when you're ready?
Matt, can you come out?
Thank you, Madam Chair.
Are you ready, Mr. McDonald?
Yes.
We're going to move on to the next item on our docket. It is docket number 2024-023, cause number 132-36, in the matter of the amended request for agency action of Ovintiv USA, Inc. for an order partially vacating the order entered in cause number 139-100 and instead pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the faucet 14-12, 3-2-13-24-5H, the 14-12 3-2-13-24-16H, and the 14-12, 3-2, 13-24-46H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Formation in sections 13 and 24, 3 South, 2 West, USM, Duchesne County, Utah. Mr. McDonald.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Ovintiv USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Mr. McDonald.
Thank you, Madam Chair. Appearing virtually pursuant to the board's June 12, 24 authorization, with me today appearing virtually are Mr. Ashley Ellison, the Senior Land Negotiator. Ashley, would you please wave your hand? And Mr. Christopher Wall, Reservoir Engineering Advisor. Chris, would you please wave your hand? All right, I would ask that these witnesses be sworn in at this time.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Madam Chair, members of the board, the resumes of both witnesses were collectively submitted as Exhibit 1 as supplemented. If separately asked, each would verify the contents of the resume are true and correct. As you are aware, Mr. Ellison and Mr. Wall have previously been recognized by the board on several occasions as experts in petroleum land management and petroleum engineering, respectively. Presuming the division has no objections, I ask that the board again recognize them as experts in those fields for purposes of this cause.
No objections by the division.
Seeing no objections, so accepted.
Thank you. And again, just to confirm, I will be moving for admission of all of our exhibits at the end of my presentation in chief.
Thank you.
Today, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 13 and 24 of Township 3 South, Range 2 West in Duchesne County. This drilling unit was established by the board's order entered in cause number 139-134. A true and correct copy of the 139-134 order was submitted as part of Exhibit 2 in this matter. The 139-134 order modified the previous board orders entered in cause numbers 131-51 and 139-90, which established sections 13 and 24 respectively as sectional drilling units for Lower Green River Wasatch production. Pursuant to the 139-90 order, Newfield, which is Ovintiv's predecessor by merger and name change, drilled 2 wells upon the section 24 drilling unit. Pursuant to the board's order entered in cause number 139-100, certain parties were compulsory pooled and declared as non-consenting parties in those 2 wells upon the section 24 drilling unit, all as outlined in paragraph 4 of the amended request for agency action. Neither well had achieved payout at the times relevant to this cause. A true and correct copy of the 139-100 order was submitted as the remainder of Exhibit 2 in this cause. Newfield drilled 2 additional wells in the Section 13 drilling unit, but no compulsory pooling order relating to those wells was ever sought. No non-consent recoupment relating to those 2 wells remains. Pursuant to the board's order entered in cause number 139-120, a special pilot drilling unit was created for the Bar F interval, which is portions of the lower Black Shale and Castle Peak members of the Lower Green River Wasatch, was comprised of sections 12 and 13 of the captioned township, little offset. Newfield drilled the Povich long lateral horizontal well in accordance with that order. The board then ordered the 139-134 order, or entered that, which expressly provides that the 139-100, the compulsory pooling order, is to be vacated, and Ovintiv, as Newfield's successor, agreed to waive any further recoupment from any non-consenting owners in those 4 existing wells, effective as of the first of the month following the date of first production of the first long lateral horizontal well drilled upon the sections 13 and 24 drilling unit. Furthermore, production allocation from those existing wells converted to the section 13 and 24 drilling unit basis as of that conversion date as well. The 139-134 order also provides that upon the first of the month following the date of production of the first long lateral horizontal well drilled upon the sections 13 and 24 drilling unit, or on the concurrently established adjacent Section 1 and 12 drilling unit, allocation from the Povich well would be allocated 50% to the Sections 13 and 24 drilling unit. That occurred on August 1st, 2022. The 139-134 order was then modified by the board's order entered in cause number 130-16 to reduce the heel-toe setbacks to 100 feet. Therefore, in accordance with the 139 and 134 order and the 130-16 order, Ovintiv drilled the 3 faucet wells at issue today, one with the first date of first production on November 9th, 2023, and the other 2 with the date of first production on November 10th, 2023. As a consequence, conversion with respect to the 4 existing wells occurred on December 1st of 2023. As alleged in the amended request for agency action, as will be established by Mr. Ellison's testimony, Mangan and Gillespie APC, which stands for a professional corporation, remains the owner of record of an undivided oil and gas interest in the drilling unit at issue. However, it was involuntarily dissolved back in the 1980s. Although Ovintiv believes it has leased all of the successors to the shareholders of that entity, it cannot be certain because no formal liquidation in accordance with the Utah statute has occurred. Furthermore, some of the fee leases were granted by parties claiming by, through, or under the estates of certain deceased parties as identified in the amended request for agency action, for whom no confirmatory Utah probate proceedings have been initiated, or if they were initiated are incomplete as to proper distribution to the heirs or devisees. As such, there is a possibility that some unknown party claiming through these estates may remain unleased and not pooled. Consequently, as to the potential unknown successors of Mangan and Gillespie and the heirs or successors of these decedents, pursuant to the board's orders entered on March 13th and May 15th of 2024, the requisite notices of opportunity to lease or participate were published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to those notices or otherwise tendered his or her share of costs for the wells. Ovintiv therefore seeks to have these parties to be compulsory pooled and also declared as non-consenting owners in the 3 faucet wells. The proofs of publication to those unknown parties were submitted as Exhibit 14 and replacement Exhibit 15 in this cause. As to the non-consenting parties, Ovintiv seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement, which terms have been previously deemed just and reasonable by the board and many other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 15.29% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of each of the 3 faucet wells. As a reminder, royalty under Indian and state leases by statute is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-6.5 and the implementing regulations at R649-28A and R649-2-9A. A copy of the amended request for agency action was mailed regular mail to all production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, to Herb Gillespie, who you will hear was a partner in Mangan and Gillespie, and to the Ute Tribe, Ute Distribution Corporation, the Bureau of Indian Affairs, and the Bureau of Land Management as the technical advisor of the Bureau of Indian Affairs due to the Indian mineral ownership, and also to the Division of Forestry, Fire, and State Lands due to UDOT ownership within the drilling unit. In addition to the published notice of opportunity to lease or participate in the Uinta Basin Standard previously mentioned, notice of the filing of the original request for agency action and the hearing thereon was also duly published in the Uinta Basin Standard on March 27, 2024, in the Deseret News on March 29, 2024, and in the Salt Lake Tribune on March 31, 2024. Under board regulations, since the hearing on the original request for agency action was continued, no further notice was required. On June 10, 2024, the division filed a response expressing no opposition to the amended request for agency action, and no other objections or responses to the amended request for agency action were timely filed. As none of the alleged non-consenting parties filed a timely response to the amended request for agency action, pursuant to Utah Administrative Code R641-104-150 and R 641-108-400, I move to enter an order of default against them. And I ask that the board rule on that.
So accepted.
Thank you. With that, I'll commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, my name is Ashley Ellison. I'm a senior land negotiator with Ovintiv USA Inc. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
And you have current responsibility over this drilling unit in that position?
Yes, sir.
All right. Would you please state for the record the corporate and binding status of Ovintiv?
Sure. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production Inc.
Mr. Ellison, I'm now going to show you what have been marked as Exhibits 3 through 7 for purposes of this hearing. Do you recognize these exhibits?
Yes, sir, I do.
Were they prepared by you or Ovintiv personnel with your review and input?
Yes, sir, they were.
Turning your attention to Exhibit 3, would you please explain to the board and the division what this shows?
Sure. This is a regional locator map. The DSU of interest is located due north of Mighton Town Site and adjacent to Highway 40.
Now turning your attention to what has been marked as Exhibit 4, would you please explain what this shows to the board and division?
Sure. Exhibit 4 is a plat to the general faucet well locations. This shows the general locations of the 5H, 16H, and 46H wells, insofar as they traverse the east half of the west half of the sections 13 and 24. They're essentially stacked wells, one on top of each other, with each producing from a different member of the spaced formations. Then, as outlined in the ARAA pursuant to the 139, 160, and 13016 orders and APDs approved by the BLM and division, 5H well was spud March 28, 2023, and completed as a producing oil well with productive intervals in the Utland Butte member of the space formations. The date of first production was November 10th, 2023. The 16H well was spud on March 23rd, 2023, and completed as a producing oil well with a productive interval in the Wasatch member of the space formations. Date of first production for this well was November 9th, 2023. And then lastly, the 46H well was spud on March 25th, 2023, and completed as a producing oil well with productive intervals in the Castle Peak member of the spaced formations. The date of first production from this well was November 10th, 2023.
Now turning your attention to Exhibit 5, would you please explain what this shows to the board and the division?
Yes, sir. No problem. This is a plat of the oil and gas ownership tracts in sections 13 and 24. There are 19 different tracts in this DSU. Tracts 8, 10, 12A, and 12B are Indian allotted ownership. Tracts 11A and 11B are tribal. And then 50% of tract 13 is UDOT owned.
And just again, a reminder to the board that the Indian and state lease royalties are not used in the average weighted fee royalty calculation per the statute. Now turning your attention to Exhibit 6, would you please explain to the board what this shows?
Yes, sir. Exhibit 6 is a DSU working interest ownership table. Ovintiv is the majority lessee and working interest owner in the DSU and is the operator of all 3 faucet wells. Other than the parties sought to be compulsory pooled, Ovintiv is the only working interest owner. Ovintiv has recorded a pooling declaration, pooling the fee leases in the DSU, and is in the process of securing ratification thereof from the Department of Forest, Fire, and State Lands relating to the state leases, and also approval of communitization agreements communitizing the tribal leases with the fee leases.
All right, and just to address the issue, you're showing 100% ownership. Is that because you believe you have the successors of Mangan and Gillespie and those decedents' estates under lease, but you're just not certain. Is that correct?
That is correct.
Okay, now turning your attention to Exhibit 7, would you please explain to the board what this shows and its significance?
Sure. This is a plat of the existing wells. All of the wells are operated by Ovintiv. The Lamb 924 and Ute Tribal 424 wells were the subject of the board's compulsory pooling order and cause number 139-100, which Mr. McDonald has addressed already. The Lamb 1413 and Fawcett 413 wells did not require a compulsory pooling order. All of these wells converted to the DSU basis as of December 1st, 2023, under the 139-134 order, and any recoupment remaining due under the 139-100 order was waived as of that date. Also shown is the Povich well, which Mr. McDonald also addressed. Under the express terms of the 139-134 order, 50% of the production from this well has been allocated to the Fawcett DSU since August 1st, 2022.
All right, Mr. Ellison, now I'm going to direct your attention to what have been marked as Exhibits 8 through 14 and Replacement Exhibit 15. Do you have those exhibits in front of you?
Yes, sir.
Okay, and are those official business records of Ovintiv?
They are, sir.
All right, would you please address Exhibits 8 and 9 and 11 through 13?
Yes, Exhibits 8 and 9 are notices of opportunity to lease or participate for the 3 Fawcett wells sent to Mangan and Gillespie APC and to Herbert William Gillespie individually. Exhibits 11 through 13 were attached to the respective notices for the respective well. Mangan and Gillespie APC remains the owner of an unleased undivided oil and gas interest in the DSU. However, it was involuntarily dissolved in sometime after 1982. No deed of distribution to shareholders appears of record, and Ovintiv was unable to determine if a liquidating agent was ever appointed. The notices sent to the last address of Mangan and Gillespie were returned as undeliverable. Excuse me. We did get a hold of Herbert William Gillespie, and he is the Gillespie of Mangan and Gillespie. Exhibit 9 reflects receipt by him of the notices on April 1st, 2024. However, as evidenced by Exhibit 10, he responded to Ovintiv's by email stating that George Mangan was the sole shareholder in that firm, and that he claimed no ownership in the DSU presently.
Okay, turning your attention. Yeah, I was going to say, turn your attention now to Exhibit 11.
Yes, sir.
Please.
Exhibit 11 are survey plats for the 3 Fawcett wells sent with each notice.
And what was turning your attention to Exhibit 12? Please explain what those are.
Yes, sir. Exhibit 12, these are AFEs sent with each notice. Mr. Wall later will testify to the actual costs associated and incurred for the respective well.
Okay, pointing out to the board, each of these notices with the reference attachments reflect compliance with the regulatory requirements under R649-1-1 and R649-2-8A. Now, Mr. Ellison, would you please explain what do you know about the succession from Mr. Mangan?
Yes, sir. So Mr. Mangan, it's our understanding that Mr. Mangan died in 1996, and Ovintiv believes that it has successors under lease. Nevertheless, pursuant to the board's order and to ensure proper regulatory compliance, notices of opportunity to lease or participate were provided by publication to any shareholders claiming by, through, and under Mangan and Gillespie APC.
And referring the board to Replacement Exhibit 15, that is the proof of publication to those shareholders as published in the Uinta Basin Standard. Mr. Ellison, can you address the issue of the decedents that you weren't able to confirm whether or not you have all their successors under lease? For sake of brevity, I'm just going to refer the board to the list of the decedents in the amended requests instead of having Mr. Ellison go through them all. But please explain what is the situation with those parties?
Yes, sir. As you mentioned, several lessors claim title to these lands through one or more of estates. the following deceased record mineral interest owners, there are 22 estates. Mr. McDonald mentioned I don't necessarily need to read all these names unless you guys want me to. And then either no Utah probate of the estates have been initiated, or if filed, they are incomplete, and that there has been no proper distribution made to the heirs or devisees. Although, based on heirship affidavits and other inquiries and research done by Ovintiv's lease broker, and except for the specific parties previously identified to be compulsory pooled or declared as non-consenting owners, Ovintiv does believe it or the other voluntary pooled working interest owners have leased all of their successors. Without an order from a Utah court confirming their succession, possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Ovintiv seeks to compulsory pool this interest.
And referring the board's attention to Exhibits 14 and Replacement Exhibit 15, those are the proof of publication to those unknown heirs or devisees. Did you receive any response to the publication or the published notices?
We did not, sir.
Okay. Now turning your attention to what has been marked as Exhibit 13, which was also Exhibit 1 to the amended request for agency action. Would you please address what that is and its significance?
Yes, sir. This is a JOA form. It's utilized in a standard industry form supplied by the American Association of Petroleum Landmen. It's Form 610. This is the 1989 version with modifications to address horizontal wells. And then Exhibit 13 is materially same form JOA that was sent with the two mailing notices to Mangan and Gillespie and Mr. Gillespie individually. The terms and conditions contained therein include the modifications made are consistent with and commonly found in more recently developed horizontal well drilling units. Ovintiv has prepared identical terms for other drilling units as operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
All right, would you point out certain provisions contained in that document that are relevant to this cause?
Yes, sir. Page 7 of the JOA is the non-consent penalty. It's the standard 100%, 300% is provided on that page. And then Exhibit C of the JOA are COPUS accounting procedures. Again, standard industry forms almost universally utilized, similar to other JOAs in the Uinta Basin. Page C3, Article 3B sets the interest rate, the prime rate, as published in the Wall Street Journal, plus 3%. Fair compensation to encourage timely payment of chargeable costs and expenses. Page C9 outlines overhead charges, $12,372.80 and $1,237.28. Exhibit A to the JOA will be amended if and once any of the unknowns are ultimately identified and their DSU gross working interests are determined.
All right, is it therefore your expert opinion that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by other working interest owners and commonly accepted by industry, in particular in the Uinta Basin with respect to horizontal well operations?
Yes, sir, that is correct.
All right, now I'm going to direct your attention to Exhibit 16. This is a two-page exhibit. I'm going to turn to the second page. Was this prepared by you or Ovintiv personnel with your review and input?
Yes, sir, it was.
All right, please explain what this shows.
Sure. This spreadsheet sort of reflects calculation of the average weighted fee or fee landowner's royalty for the drilling units as of the date of spud of each of the faucet wells. The average weighted fee royalty is 15.29%. This number does not include Indian or state royalty per statute. Just as a aside, 15.29 is lower than some of the other ones the average weighted royalty is calculated. And this is simply because this area is comprised of a lot of old leases. There's 1/6 royalties, and then there's two 120-acre tracts that are leased at 1/8, so 12.5%, just to head off any questions in the future of why the royalty is slightly lower than some of the other ones we've done in the past.
All right, and then just for the record, would you confirm all other land allegations made in the amended request for agency action?
That's correct.
All right. Now turning your attention to the certificate of service, do you have that in front of you?
Yes, sir.
All right, this is a pleading prepared by my office and already on file in this cause. Can you identify who those people are and how the addresses and their names were determined?
Yes, sir. These are person shown. Person showns are all the production interest owners within the DSU. Addresses derived from title opinions effective as of October 6, 2023, as updated by the search of the county records by Lone Wolf and Ovintiv's internal records. Lone Wolf is the broker that we use to help with a lot of this stuff. Also the tribe, UDC, UDOT, Division of Fire, Forestry, State Lands, and governing federal agencies.
Madam Chair, with that concludes my examination of Mr. Ellison.
Thank you. Division?
Thank you for your testimony, Mr. Ellison. The division does not have any direct questions on this. I just do have one comment on Exhibit 4. I noticed that the sections are labeled 6 and 7, but I just want to confirm, is the ownership though reflected there for sections 13 and 24?
Yes, that is 100% my error.
Okay.
It should be 13 and 24.
Okay, thank you. That's
Thank
all
you for that
comments we have.
clarification.
Good point.
Mr. McDonald, can you proceed?
Any questions from the board for the witness? Or?
I have a question.
Mr. Moon?
So even though Mr. Gillespie was named as one of the owners of this, he claimed no interest in the ownership of that.
That's correct. The Exhibit 10, I was going to say Exhibit 10 reflects his email response stating that he was not a shareholder of that entity and therefore claimed no mineral interest through that entity.
So that can happen. You can be named in the name, but not be a shareholder. Okay.
I found it interesting myself too, but that's what
I was just wondering if you have documentation that backs that up, or do you just take his word for it?
Well, again, that's why we put that in there, and then that's why it was named that any shareholder claiming buy through under Mangan, just in case he proved it incorrect.
And so you didn't take a lease from him because he claimed no interest. Okay. Okay.
That is correct.
And then just another quick question. I noticed in the average weighted shareholder royalty, Duchesne County is listed, but I don't see UDOT for their piece. Remind me again if it's, I know federal and state leases are not.
Correct. Under the statute, the Division of Forestry, Fire, and State Lands acts on behalf of UDOT for any mineral development.
Right.
So it's a state lease issued by DFFSL, which benefits UDOT, the same that SITLA benefits the schools
and they're
and
not included in the average weighted.
correct.
Okay, but a Duchesne County is.
It's considered a fee owner. Yes.
Mm-hmm. Okay. Okay. And then just one final question on that Povich well. So that was drilled under a prior spacing order that was offset.
Yeah, what happened with that was, again, if you recall, the board, Ovintiv had a lot of pilot program wells, and this one was the one that they wanted to test the bar F, and I can't remember, but I think it was because of surface issues. They did an offsetting unit compared to all the other ones.
Okay.
And so when the 139, 134 order came about, which was, the general one, the decision was to split when a well was drilled on the other two ones, that 50% would go to the one two-sectional drilling unit and 50% to the other.
Okay. I shouldn't remember that ever happening before, just deciding to split a well.
That was the only one at that time that was that situation, so that's how they addressed it.
Okay. Okay, thank you.
Board, do you have any further questions for this witness? Mr. McDonald, please proceed.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Wall. Mr. Ellison, you can leave now at this point. Mr. Wall, would you please state your name and business address for the record?
Yes, my name is Christopher Wall. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what's your current position with Oventive?
I'm a reservoir engineering advisor with jurisdiction over Uinta.
Right. And in particular, this drilling unit?
Yes.
Right. Turning your attention to what has been marked as Exhibit 17. This is a 2-page exhibit. Was this prepared by you or Oventive personnel with your review and input?
Yes.
All right. Would you please explain what this shows?
Yes. Exhibit 17 is a summary of the actual costs invoiced to Oventive and incurred in drilling and completing, as well as the operating costs for each of the faucet wells through March 31st of 2024.
And were these costs within reasonable variance of the AFEs that were sent out?
Yes.
All right. Is it your expert opinion that the costs were fair, reasonable, and necessary, and that these wells were deemed economically feasible as used in the 139, 134 orders?
Yes.
All right. Could you please address what is the estimated plug-in and abandonment cost for each of these wells?
Yes, the plug-in abandonment cost is $75,000 per well, which is consistent with Uinta Basin P&A costs charged to and by Oventive. This is based on 100% working interest.
Okay, now turning your attention to what have been marked as Exhibits 18 and 19. Do you see those exhibits?
Yes.
And were they prepared by you or Oventive personnel with your review and input?
Yes.
All right, turning your attention to Exhibit 18, would you please explain what this shows and its significance to the board and division?
So Exhibit 18 is a plat of all the nearby existing horizontal well development at the time the faucet wells were spud.
Okay, and there was very few Castle Peaks at that time, is that correct?
There was a limited number of Castle Peaks.
Okay.
At the time.
Now turning your attention to Exhibit 19, would you please go through what this shows and its significance to today's hearing?
Yes, Exhibit 19 is a summary of the risks that oil and gas operators encounter in the Uinta Basin. Starting with geologic risks, there's possible unexpected changes in structure, making it a little bit challenging for steering horizontal laterals. There's also possible unexpected stratigraphic variations. On the operational side, you have shallow hazards with water flows. Uteland Butte interval has high clay content and has the potential to collapse and stick drill pipe and casing. Drilling offset developments, both vertical and horizontal, increase your risk of depletion, which affects your hole stability. And some recent examples of trouble during operations is the collapse casing on the Black Hair 7H and the Bruce 42H this year. We've had cementing challenges on the Tomlin 46H, causing us to lose half the lateral that we would like to produce. And then also the Abbott 46H, we sheared the BHA, attempting to steer in the lateral, and again caused us to call our wellbore short. In addition to that, you have commercial challenges with future oil price uncertainty, and then also the future refinery and rail car availability to sell your product. In this particular case, the faucet 46H did suffer stuck pipe. We weren't able to require to fish the entire BHA. We ended up having to sidetrack and re-drill the lateral.
All right, based on these exhibits, is it your expert opinion then that the 300% risk assessment award was justified based on these geologic and actual risks incurred?
Yes.
All right, and just for the record, would you confirm all of the other engineering-related allegations of the amended request for agency action?
Yes.
Madam Chair, that concludes my examination of Mr. Wall.
Thank you. Division?
The division has no questions for Mr. Wall.
Board, do you have any further questions? Mr. Moon?
What was your approximate cost on that sidetrack and re-drill on that well?
Yep, I have that. Just a second. So it's approximately $400,000.
Thank you.
Board, do you have any further questions? Mr. McDonald, back to you.
Thank you, Madam Chair. At this point, I would move for admissions of Exhibits 1 as supplemented, 2 through 14, Replacement Exhibit 15, and Exhibits 16 through 19 inclusive.
So admitted.
Any objection?
No objection.
Thank you.
So admitted.
With that, Madam Chair, we believe that all the statutory and regulatory requirements have been satisfied. We would ask that the amended request for agency action be approved as submitted. I'll reserve a little bit of time then if after the division statement.
Division.
Thank you. The division in this case reviewed the request and the exhibits, and as a result, the division filed a notice of non-opposition for this request. And after the testimony presented here today, the division is in support of this request.
Thank you. Board? Do we need to deliberate?
Just one more quick question.
Mr. Moon?
Just a curiosity question. So this is a good comparison of the Uteland Butte. What were the other two formations? Castle Peak and Upper Wasatch?
Yes.
Could you just talk about the production in each of those, and if it was as expected with the differing formations?
Yeah, I guess I can make some general comments. I think in this area, the Fawcett Uteland Butte well is really good. It's meeting our expectations and it's potentially beating what we have as a type curve for the area. The Castle Peak is also a really good well, probably right at or maybe just slightly under our type curve for that area. And then the Upper Wasatch is also a really good well for us. It's meeting our type curve expectations.
Okay, but the Uteland Butte was your best well then, as expected?
Yeah, typically the Uteland Butte formation is your most prolific producer.
Okay, thank you.
Mr. McDonald, do you have any further summation?
No, just to thank again the board and for your time and effort, and also to give a shout out to the IT people for allowing the virtual appearance by the witnesses.
Thank you. Board, do we need to deliberate, or are we prepared for a motion?
Madam Chair, your microphone is muted.
Sorry. Do I have a motion from the board?
I move that we approve the request for agency action.
I'll second that.
It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? Hearing none, it passes unanimously. Fred, would you please prepare the order?
Certainly, thank you.
So just read this over.
Number 5, and it has been dismissed, so we can keep on rolling. But since it's
Oh.
on the agenda, you can just read this.
I don't have, should I read the whole thing or
Just say
just
docket number 2024,
has
and
this
then
matter?
has been dismissed. Go right.
We are going to move along to docket item number 5. This is docket number 2024-019, cause number L dash 2024-01. Please note this matter has been dismissed without prejudice.
Thank you, Madam Chair.
Quick and easy.
Quick and easy. We hope to refile soon.
Thank you.
Groundhog's Day for me.
Okay, we are moving on to docket item number 6. Docket number 2024-031, cause number 132-39. In the matter of the request for agency action of Oventive USA, Inc. for an order modifying the board's order entered in cause number 139-137 to declare certain parties as non-consenting owners in the Andre 14-7-6-3-2 WH and the Andre 15-7-6-3-2 WH wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations composed of sections 6 and 7, 3 South, 2 West, USM, Duchesne County, Utah. Mr. McDonald.
Thank you, Madam Chair. Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Oventive USA, Inc.
Division.
Gary White, Assistant Attorney General. I represent the division, and I'm here with Peter Pankey and Colton Goodrich, Division Specialists.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today are Mr. Peter Burns and again Mr. Christopher Wall, appearing virtually pursuant to the board's June 12th order and authorization. Mr. Burns is the land advisor and Mr. Wall is the reservoir engineer advisor. I would ask that they be sworn in at this time.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Madam Chair, members of the board, the resumes of both witnesses were submitted collectively as Exhibit 1 as supplemented. If separately asked, each would verify the contents of their resumes are true and correct. As you're aware, Messrs. Burns and Wall have been previously recognized by the board on several occasions as experts in petroleum land management and petroleum engineering, respectively. Presuming the division has no objection, I ask that the board again recognize them as experts in those fields for purposes of this cause.
Division.
No objection.
Board. So it's accepted.
Thank you. I also want to confirm that you received the supplement to Exhibit 30, which is just the additional return receipts that we received
Yes.
since the original filing.
It's been received.
And again, I will be moving forward admission of my exhibits in entirety at the end of my presentation in chief.
Thank you.
Members of the board, this cause involves modifying the board's previously entered compulsory pooling order in cause number 139-137, covering the drilling unit established for Lower Green River Wasatch production comprised of the entirety of Sections 6 and 7, Township 3 South, Range 2 West, in Duchesne County. This is a unique situation where the 2 Andre wells at issue in this cause were drilled at the time the 139-137 order was entered, but for some unknown reason were not addressed in that order. A true and correct copy of the 139-137 order was submitted as Exhibit 2 in this cause. As a consequence, Oventive is before you today seeking to modify the 139-137 order to first, confirm all of the parties are compulsory pooled in the drilling unit, including certain parties who are not specifically identified in that order. Secondly, to declare various parties as non-consenting owners in the 2 Andre wells. And third, to replace the joint operating agreement adopted as part of that order with a newer joint operating agreement more tailored to current long lateral horizontal well development. Since the request for agency action was filed, Alan D. Mummert, one of the parties named in the request for agency action to be deemed a non-consenting party in the Andre wells, leased to Oventive. In addition, the heirs of Max A. Howder, one of the decedents that was named in the request for agency action, have now been formally determined in a Utah probate proceeding, and Oventive has confirmed all of those heirs are leased. Consequently, we will verbally amend the request for agency action to exclude them from being compulsory pooled. As to the remaining specifically named parties, the requisite notices of opportunity to lease or participate were either received or, if unlocatable, were served by publication in accordance with the board's order entered on May 13th, 2024. No timely responses to those notices were received, and consequently, Ovintiv seeks to ensure they are compulsory pooled and declared as non-consenting owners in the Andre wells. Furthermore, some of the fee leases that were granted by parties claiming buy-through are under the estates of certain deceased parties, as identified in the request, with the exception of Max Howder, as previously mentioned, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there's a possibility that some of these unknown parties claiming through these estates are unleased and not currently pooled. Consequently, as to those potential unknown heirs or successors, also pursuant to the board's order entered on May 13th, 2024, the requisite notices of opportunity to lease or participate were published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to these notices, and Ovintiv therefore seeks to have these parties to be compulsory pooled and declared as non-consenting owners. The proof of publication to those unlocatable or unknown parties was submitted as replacement exhibit 25 in this cause. As to the consenting parties, Ovintiv seeks imposition of a 300% risk compensation award and the substitution of a joint operating agreement for that adopted in the 139-137 order, which terms are consistent with those executed by other working interest owners in this drilling unit and are more appropriate for current long lateral well development and have been previously deemed just and reasonable by the board and many other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 17.951915% cost-free royalty, representing the average weighted fee royalty in the drilling unit, calculated as of the date of spud of each of the 2 Andre wells. Again, royalty under Indian and federal leases by statute is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-2-9A. A copy of the request for agency action was mailed certified mail, return receipt requested to the known locatable parties to be compulsory pooled, and via regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, including the Ute Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, and the BLM due to the Indian and federal mineral ownership within the drilling unit. In addition to the published notices of opportunity to lease or participate in the Uinta Basin Standard previously mentioned, notice of the filing of the request for agency action and the hearing thereon was duly published in the Salt Lake Tribune on June 2nd, 2024, the Uinta Basin Standard on June 5th, 2024, and the Deseret News on June 7th, 2024. On June 10th, 2024, the division filed a response expressing no opposition to the granting of the request for agency action, and no other objections or responses to the request were timely filed. As none of the alleged non-consenting parties filed a timely response to the request for agency action, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, I move to enter an order of default against them and ask that the board rule on that. Thank you. With that, I'll commence my examination. Mr. Burns. Mr. Burns, would you state your name and business address for the record?
Yes, Peter Burns, and Ovintiv's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what's your current position with Ovintiv in your relation to this drilling unit?
So I'm a land advisor with responsibility over this drilling unit, among others.
For the record, would you please state Ovintiv's corporate and bonding status?
Yes, Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production, Inc.
Mr. Burns, I'm going to direct your attention to now what have been marked as Exhibits 3 through 7 Maybe. Hang on a second here. There we go. Do you recognize these exhibits?
Yes.
Were they prepared by you or Ovintiv personnel with your review and input?
Yes.
Turning your attention to Exhibit 3, would you please explain what this exhibit shows and its significance to the board and the division?
Yes, Exhibit 3 is a regional locator plat. This particular DSU, Section 6 and 7, Township 3 South, 2 West, highlighted in yellow, outlined in red. DSU is located 2 miles west of the Ioka community, with Highway 87 as its northern boundary, and also 5 miles northwest of the Mighton town site.
All right, turning your attention to Exhibit 4, would you please explain what this shows?
Yes, Exhibit 4 is just a snapshot of the BLM master title plat, reflecting the various lots within Sections 6 and 7. This is a correction section, so this results in a DSU acreage of 1,264.45 gross acres.
All right, now turning your attention to Exhibit 5, would you please explain what this shows and its significance to today's hearing?
Yes, Exhibit 5 is a plat of the mineral ownership within this DSU, but also the general well location of the Andre wells. And as outlined in the RAA pursuant to the board's Uteland Butte pilot order entered in cause number 139-113, the APD is approved by the division and federal agencies. Andre 14-7 well was spud on November 11th, 2014, and completed as a producing oil well with productive intervals in the Uteland Butte member, with first production on April 23rd of 2015. Additionally, the Andre 15-7 well was spud on November 12th, 2014, and completed as a producing oil well with producing intervals in the Uteland Butte member, also with first production on April 23rd, 2015. 139-134 order subsequently vacated the 139-113 order and established the DSU for the entire Lower Green River Wasatch Formation. The 139-137 order was required under the 139-134 order to modify a previous board compulsory pooling order, number 139-115, which addressed existing vertical wells within the DSU to waive further recoupment. 139-137 order compulsory pooled interest in the DSU without naming all owners, and most importantly, not address the 2 Andre wells or the participation status of owners therein.
Now turning your attention to Exhibit 6, this is a 3-page exhibit. Can you just outline again what this shows and its significance?
Yes, Exhibit 6 is the plat of the oil and gas ownership tracts within this DSU. Shows 17 different tracts. Tracts 3 through 5 and 17 are Indian allotted tracts. Tracts 6 and 16 are tribal, and 50% of tracts 13 and 15 are federally owned.
And again, as a reminder, the Indian and the federal lease royalties are not included in the calculation of the average weighted fee royalty. Okay, now turning your attention to Exhibit 7, please explain what this shows.
This Exhibit 7 is just a DSU working interest ownership summary snapshot. As you can see, Ovintiv is the majority lessee working interest owner within this DSU, and we are the operator of the 2 Andre wells. XCL Asset Co. LLC, Vaquero Utah Holdings LLC, and Blue Diamond Oil Corporation are also working interest owners in this DSU. All are parties to a JOA naming Ovintiv as operator. Their respective elections were governed by these joint operating agreements. Ovintiv has recorded a pooling declaration pooling the fee leases in the DSU and have secured approval of a communitization agreement, essentially pooling the tribal and federal leases with all fee leases.
All right, Mr. Burns, I'm going to direct your attention now to Exhibits 9 through 24 and Replacement Exhibit 25. Do you have those exhibits in front of you?
Yes.
And are those all official business records of Ovintiv?
Yes.
Okay. Explain what Exhibits 9 through 21 are.
These are the notices of opportunity to lease or participate for the 2 Andre wells. Exhibits 22 through 24 were attached to the respective notice for each respective well.
And just to identify, what is Exhibit 22?
Exhibit 22 is the survey plat for the 2 Andre wells that was sent with each notice.
And Exhibit 23?
Exhibit 23, the AFEs that were sent with each notice. Mr. Wall will testify as to the actual costs invoiced and incurred for each of those wells.
Okay, and for the board direction, each notice was with the reference attachment reflects compliance with the regulatory requirements under R649-1-1 and R649-2-A. I want to note that these notices were sent prior to the board's stated preference in March of 2023 to include the specific share of interest and costs in these notices. All right, now, would you please turn your attention, there was certain parties who either did not pick up or were unlocatable with respect to these notices. Can you address those?
Sure. Shirley Chapman, who was Exhibit 14, and then Tennille Smith, Exhibit 17, failed to pick up their notices, and Wesley Smith, Exhibit 18, is an unlocatable. Nevertheless, pursuant to the board's May 13th, 2024 order, and to ensure proper regulatory compliance, notices of opportunity to lease or participate were provided by publication to these parties.
All right, would you please state for the record each of the party that's being compulsory pooled and what their gross working interest is in the drilling unit?
Sure. We show the gross working interest of each of these compulsory pooled parties to be, for David Rhodes, 0.000723%. For Peggy Rhodes, it's 0.000723%. Daniel Rhodes, 0.000723%. Doug Rhodes, 0.000723%. Nancy Rhodes, 0.000723%. For Shirley Chapman, sometimes known as Shirley Marie Rasmussen, it's 0.000096%. Donald Smith, 0.00072%. Leland J. Smith, 0.00036%. Neil Gay Smith, 0.000036%. Wesley Clay Smith, 0.00036%. Benjamin J. Smith, 0.00036%. Greg Miller McFarland, 0.000241%. Laura McFarland, aka Laura Twiss, 0.000241%. And Janelle Smith Hicks, 0.000290%. This is a total, comes to a total of 0.004699%, which equates to 0.059 net acres within the DSU.
All right. Again, we talked about that Ovintiv has identified that there's a bunch of deceased parties that there haven't been any probates, but you think that they've been leased, the successors have been leased. Again, in the interest of brevity, I'm not going to have you testify to all those names, and I would ask that the board take notice that they're in the request for agency action. Again, would you please address about those parties and what Ovintiv's done about it?
Yeah, as Mr. McDonald mentioned, there are several lessors claiming title in these lands through one of the more of the estates listed within the RAA. For these owners, either no Utah probate of the estates has been initiated, or if it's filed, they're incomplete, and that there has not been proper distribution made to the heirs or devisees. Although based on our airship affidavits and other inquiries and research done by our lease broker, except for the specific parties previously identified to be compulsory pooled and declared as non-consenting owners, Ovintiv believes it or the other voluntarily pooled working interest owners have leased all of their successors. But without an order from the Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Ovintiv seeks to compulsory pool their interests.
Okay, referring the board and the division to replacement exhibit 25, that's the proof of publication to Ms. Chapman, the two Smiths, and to the unknown heirs or devisees. Mr. Burns, to your knowledge, was there any responses to those published notice ever received?
We did not receive any response.
All right, now I'm going to direct your attention to what has been marked as Exhibit 24. This was also Exhibit A attached to the request for agency action. Would you please address what that exhibit is?
This Exhibit 24 is the proposed JOA for this compulsory pooling order. This is a form utilized, standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. Exhibit 24 is materially the same form JOA that's been sent the mailed notices of opportunity to lease or participate. Terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including those JOAs signed by XCL, Caro, and Blue Diamond covering this DSU. Ovintiv has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which we are a non-operator and drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators. More current terms for the Uinta Basin long lateral horizontal well development than those adopted in the 139-137 order.
Okay, can you address, again, the relevant provisions in the JOA that are relevant to a compulsory pooling matter?
Yes, page 7 addresses the non-consent penalty within the JOA. As is standard, 100%, 300% non-consent penalties provided. And then further, Exhibit C of the JOA is the COPUS accounting procedure form. Again, this is a standard industry form, almost universally utilized, similar to other JOAs within the Uinta Basin. The important components here within the COPUS are found on page C3. Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%. This has been deemed as fair compensation and to encourage timely payment of chargeable costs and expenses. And lastly, page C9, the COPUS outlines the overhead charges, which in this JOA is defined as a 10,000 and 1,000 drilling versus producing rate. The Exhibit A to the JOA will be amended if and once any of the unknowns are ultimately identified and their DSU gross working interests are determined.
Okay, is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by other working interest owners in this drilling unit and with those commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes.
Right, now I'm going to turn your attention to Exhibit 26. This is a 5-page exhibit. I'm just going to show the last page on here. Was this prepared by you or Ovintiv personnel with your review and input?
Yes.
All right, would you please explain what it shows?
Yes, so Exhibit 26 is the average weighted fee landowners royalty exhibit. This reflects the calculation of the average weighted royalty for the drilling units as of the date of spud of each of the Andre wells. Average weighted fee royalty is 17.951915%. And as mentioned before, this does not include Indian or federal royalty per the statute.
Right,
and just these wells.
Go ahead. I was going to ask you, go ahead and address the payout status of these wells.
Okay. Yeah, so these wells were drilled several years ago. Obviously, the 14H, the Andre 14 well has not achieved 100% payout. Andre 15 well achieved 100% payout in January of 2023, but has not reached a 300% payout.
Right, and for the record, would you confirm all other land-related allegations of the request for agency action?
Yes.
Finally, Mr. Burns, I'll direct your attention to the certificate of service. Do you have that in front of you?
Yes, I do.
All right, this again was a pleading prepared by my office and already on file in this cause. Would you please explain the people that are shown on there, how they were determined and what their addresses were?
Yeah, the people shown are the production interest owners within this DSU, and the addresses were derived from title opinions effective as of October 25th, 2012, as to Section 6, and December 3rd, 2014, as to Section 7, as updated by a search of the BIA, BLM, and county records by Lone Wolf Energy, our lease broker, along with Oventive's internal records. And this certificate of service and RAA was also sent to the tribe, UDC, BLM, and BIA.
Madam Chair, that concludes my examination, Mr. Burns.
Thank you. Division?
We have no questions for this witness. Thank you.
Board, do you have questions? Mr. Church?
Mr. Burns, I just need to clarify. In Exhibit 7, you say the working interest owners have an existing JOA. Is that the JOA that was from 139, 137 that was attached to that drilling unit?
No, this is going to be, the JOA is a more current version.
So is the JOA the one that you're recommending that it be attached to the current RA?
Correct, yes. A current JOA, the one we're asking that is part of the compulsory pooling today.
Okay, and here again, just to clarify, it is to be updated, the JOA, because the old one didn't address all of the horizontal drilling aspects that needed to be covered in this one?
Yes.
Okay, thank you.
Have these people that are being compulsory pooled today been paid all along since these are existing wells? Are you holding those funds in escrow?
Yeah, they're held in escrow. But as we, assuming this order is approved, we would then move to pay them the average weighted royalty.
Back to first production?
Yes.
Okay. Board, do you have any further questions? Seeing none, are we ready for a motion?
Oh, we still have another
Back
witness.
to
Madam
Fred.
Okay. I'll commence my examination of Mr. Wall now. Mr. Wall, would you please state your name and business address for the record?
Yes, name is Christopher Wall. Business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what is your current position with Oventive, and do you have any supervisory capacity over this drilling unit?
My position is Reservoir Engineer Advisor, and I have jurisdiction over this development as well as others.
All right. Turning your attention now to Exhibit 27. This is a 2-page exhibit. Was this prepared by you or Oventive personnel with your review and input?
Yes.
All right. Would you please explain what this shows?
Exhibit 27 is a summary of the actual costs invoiced to Oventive and incurred in drilling and completing and operating costs for each of the Andre wells through February 29th, 2024.
All right. And how do these costs relate to the AFE costs? Are they in reasonable variance?
Yes.
So is it your expert opinion that these costs were fair and reasonably and necessarily incurred, and that the wells were deemed economically feasible, as that term is used in the applicable spacing order?
Yes.
All right, would you please, for the record, state what is the estimated plugging abandonment cost for each of the Andre wells?
The P&A costs are $75,000 per well, which is consistent with Uinta Basin P&A costs charged to and by Ovintiv based on 100% working interest ownership.
Right now, I'm going to turn your attention to Exhibits 28 and 29 for purposes of this cause. Again, do you recognize these exhibits, and were they prepared by you or Ovintiv personnel with your review and input?
Yes.
All right, turning your attention to Exhibit 28, would you please explain what this shows?
Exhibit 28 is a plat of nearby existing horizontal development at the time the Andre wells were spud.
And again, these wells were drilled under a pilot order, so they were one of the first ones drilled out there. Is that correct?
Yes.
Okay, now turning your attention to Exhibit 29, would you please explain what this says and its significance to today's hearing?
Exhibit 29 is a summary of the risks of drilling and completing as well as operating wells in the Uinta Basin. First, on geologic risk in this area, there was some geosteer challenges due to the lack of well control. There is variable stratigraphy, especially high clay intervals and other structurally weak zones leading to possible hole stability issues. On the drilling and operating side, you have capital cost expectation due to the lack of well control. In other words, we hadn't done a bunch of activity here, so we weren't really sure what the wells would cost. You do have shallow hazards with artesianal water flows. The Uteland Butte has high clay intervals with potential to stick and collapse drill pipe and casing. Some recent examples is the Black Hair 7H and Bruce 42H with collapsed casing, cementing challenges in the Tomlin 46H, and then also sharing a BHA in the lateral of the Abbott 46H. Outside of that, on the commercial side, there is future oil price uncertainty and also future marketing with refinery and rail availability. On these particular wells, there were no operational challenges that were encountered.
But again, they were one of the first ones that were drilled under a pilot program. Is that correct?
That is correct.
All right. Is it your expert opinion then that for these reasons, a 300% risk assessment award is justified?
Yes.
All right. Would you please confirm for the record that all of the other engineering-related allegations of the request for agency action?
Yes, confirmed.
Thank you. Madam Chair, that concludes my examination. Mr. Wall?
Thank you. Division, do you have questions?
No questions, thank you.
Board? Mr. McDonald?
Thank you, Madam Chair. With that, I would move for admissions of Exhibits 1 as supplemented, 2 through 24, Replacement Exhibit 25, and Exhibits 26 through 29 and 30 as supplemented.
Just 1 second here. Okay, any questions?
Any objection?
Division?
No objection to the exhibits.
Board? So admitted.
Thank you, Madam Chair. With that, we believe all the statutory and regular requirements have been satisfied for the granting of the request for agency action as submitted. I'll reserve of closing remarks after the division's made its statement.
Division, please.
Thank you, Madam Chair. After reviewing the submissions, the exhibits, and hearing the testimony today, the division has no objection to granting this request.
Board? Back to you, Mr. McDonald. Did you have a question? Back to you, Mr. McDonald.
Thank you, Madam Chair. Once again, thank you, board members, for allowing the witnesses to appear virtually. And again, a shout out to the IT people for making it go very smoothly. Thank you.
Thank you. Board, do we need to deliberate, or are we ready for a motion? Could I get a motion?
I move that we approve the request for agency action.
And a second, please?
I'll second that.
Thank you. It's been moved and seconded. All in favor?
Aye.
Opposed? Please show it was unanimous. Would you please prepare the order, Mr. McDonald?
Certainly, Madam Chair. Thank you.
Thank you. All right, we have the option at this point to do lunch or to try to do one more item. Are you doing this one also, Mr. McDonald?
Yes, ma'am.
How long do you think it will be?
That one took about a half an hour, so I think this one should be even less.
Okay, let's go forward and do one more item.
Madam Chair, just for some housekeeping here, we have an updated Exhibit 7 for this matter. I think Ms. Carter's handing it out to you.
Okay.
And I'll explain why it's updated.
Mr. McDonald, tell me when you're set up.
Okay, 3.
We're good.
Okay. Yeah. We're moving on to docket number 2024-031, cause number 132-39. In the matter of the request for agency action of Ovintiv USA, Inc. for an order modifying the board's order entered in cause number 139-137 to declare certain parties as non-consenting owners. Hold on. Sorry, forgot to cross that one off. Let's move on to item number 7, unless you'd like to redo that.
No, I don't think anybody is.
It started to sound familiar. Docket number 2024-032, cause number 132-40. In the matter of the request for agency action of Ovintiv USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Colorado 16-7, 4-2, 8-5-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of sections 5 and 8, 4 South, 2 West, USM, Duchesne County, Utah. Mr. McDonald.
Thank you, Madam Chair. Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Ovintiv USA, Inc.
Division.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. And I also have Peter Pankey and Colton Goodrich here as well.
Thank you.
Thank you, Madam Chair. With me appearing virtually again pursuant to the board's June 12th order and authorization are Mr. Peter Burns, Land Advisor, and Mr. Christopher Wall, Reservoir Engineering Advisor. And for purposes of the record in this cause, I ask that they be sworn in again.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Again, Madam Chair, just to, in purposes of brevity, the resumes were submitted as Exhibit 1 is supplemented. Mr. Burns and Mr. Wall have been accepted as experts in the fields of petroleum land management and petroleum engineering. And again, presuming the division has no objection, we ask that the board recognize them in those fields as experts for purposes of this cause as well.
Division.
No objection.
Board. No objection, so accepted.
Thank you. Just want to confirm that you received the supplement to Exhibit 28, which again was the return receipts supplemented from the time we filed before.
Yes, we've received
and
them.
Ms. Carter distributed the updated Exhibit 7 so that you all have that?
Yes.
All right, great. And then I will also again be moving for admission of the exhibits at the end of my presentation in chief.
Thank you.
Members of the board, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of Sections 5 and 8 of Township 4 South, Range 2 West in Duchesne County. This drilling unit was established by the board's order entered in cause number 139-150. A true and correct copy of the board's 139-150 order was submitted as Exhibit 2 in this cause. In accordance with the 139-150 order, Newfield, which is Ovintiv's predecessor by name change and merger, drilled the subject Colorado well with date of first production on August 31st, 2018. As alleged in the request for agency action, as will be established by Mr. Burns' testimony, several parties were sent the requisite notices of opportunity to lease or participate in the Color Row well, but they failed to respond within the appropriate 30-day time period set by regulation. As such, Ovintiv seeks to compulsory pool them in the Section 5 and 8 drilling unit and to declare them as non-consenting owners in the well. Furthermore, some of the fee leases were granted by parties claiming by-through under the estates of decedents identified in the request for agency action, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there's the possibility that some of these unknown parties claiming by-through or under these estates is currently unleased and not pooled. Consequently, as to those potential unknown heirs or successors, pursuant to the board's order entered on May 13th, 2024, the requisite notice of opportunity to participate was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to the notices or otherwise tendered his or her share of the cost for the well. Ovintiv is therefore seeking to have these parties also compulsory pooled and declared as non-consenting owners. The proof of publication to those unlocatable or unknown parties were submitted as Replacement Exhibit 23. Since the request for agency action was filed, a number of parties originally sought to be compulsory pooled either have leased or sold their interests to Ovintiv. These include Scott Robert Larson as personal representative of the estate of Adrian Larson, Allen and K. Blood LLC, Chad Weber, Robert D. Noble, Shirley Huber, successor trustee of the Glenn J. Huber Family Living Trust, dated August 1st, 1982, Tori Weber, and Travis Weber. Consequently, we are verbally amending the request to exclude those parties. As to the remaining non-consenting parties, Ovintiv seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement, which terms have been previously deemed just and reasonable by the board and many other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to an 18.930074% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of spud of the Color Row well. Royalty under the Indian leases by statute is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5 and the implementing regulations at R649-2-8A and R649-29A. A copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, also to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and the BLM as the technical advisor to the BIA due to the Indian mineral ownership within the drilling unit. In addition to the published notice of opportunity to lease or participate in the Uinta Basin Standard previously mentioned, notice of the filing of the original RIA and the hearing thereon was also duly published in the Salt Lake Tribune on June 2nd, 2024, in the Uinta Basin on June 5th, 2024, and in the Deseret News on June 7th, 2024. On June 10th, 2024, the division filed a response expressing no opposition to the granting of the request. No other objections or responses to the request were timely filed. Consequently, we request pursuant to Utah Administrative Code R641-104-150 and R641-108-400 to enter a order of default against them and ask that the board rule on that.
Division, do you have any problem?
No objection.
Okay. Accepted.
Thank you. With that, I'll commence my examination. Mr. Burns. Mr. Burns, would you again please state your name and business address for the record?
Yes. Peter Burns, and Ovintiv's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what's your current position with Ovintiv and its relation to this drilling unit?
Sure. I'm a land advisor with responsibility over this drilling unit, among others.
And for purposes of the record of this cause, would you please state Oventive's corporate and bonding status?
Yes. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
All right, I turn your attention to what have been marked as Exhibits 3, 4, 5, 6, and updated Exhibit 7. Do you recognize these exhibits?
Yes.
Were they prepared by you or Oventive personnel with your review and input?
Yes.
Turning your attention to Exhibit 3, would you please explain what this represents to the board and division?
Yes, Exhibit 3 is our standard regional locator plat. The lands at issue, Sections 5 and 8, Township 4 South, Range 2 West, is outlined there in red. This DSU is located along Highway US 40 between Bridgeland and the Mighton Town site.
Now turning your attention to Exhibit 4, please explain what this shows.
Yes, Exhibit 4 is a snapshot of the BLM master title plat of this DSU, reflecting the various lots in Sections 5 and 8. This is also, Section 5 is a correction section. So the total DSU gross acreage is 1,294.16 gross acres.
Now turning your attention to Exhibit 5, please explain what this shows.
Yes, Exhibit 5 is a lease plat, also a plat of the mineral ownership within the unit. This shows the Colorado 7H well within the west half of the DSU. There is tribal and allotted mineral ownership, the allotted being the dark green and the tribal being the light green. As outlined in the RAA, pursuant to the APDs approved by the division and the relevant federal agencies, the Colorado well was spud on May 27th, 2018 and completed as a producing oil well with productive intervals in the Utland Butte member and first production on August 31st of 2018. There are no other wells within this DSU.
Now turning your attention to Exhibit 6, this is a two-page exhibit. Would you please explain what this shows?
This Exhibit 6 is a plat of the oil and gas ownership tracts in Sections 5 and 8. There are 16 different tracts in this DSU. Tracts 5, 6, 12, and 13 are either wholly or 95% Indian allotted. Tracts 1 and 11 are tribal, and the remainder is owned in fee.
And again, as a reminder, the Indian royalty is not included in the calculation of the average weighted landowner's royalty. Now turning your attention to updated Exhibit 7, would you please explain what this shows?
Yes, Exhibit 7 is a DSU working interest summary for this particular Colorado unit. This is based on this revised original Exhibit 7 is based on leases obtained after the RAA was filed. The new aggregate interest to be compulsory pooled is 1.110868%, which I will detail here shortly. And as you can see, Oventive is the majority lessee working interest owner in the DSU and operator of the Colorado well. Otter Creek LLC, Snowbird Acquisitions LLC, PEC Exploration LLC, Kaiser Francis Oil Company, and Finley Production Company LP are also working interest owners in this DSU, but all are parties to JOAs, which name Oventive as the operator and thereby voluntarily pooling each of their interests. Their respective elections were governed by those JOAs. And we have recorded a pooling declaration, which pools all the fee leases in this DSU. And we've also secured approval of a communitization agreement, which effectively pools all the tribal leases with the fee leases.
All right, and just to clarify, again, updated Exhibit 7 is actually updated from the time the original Exhibit 7 was filed to today due to leases or acquisitions that were occurred in that time period. Is that correct?
Yes, that's correct.
All right, thank you. Now I'm going to refer you to Exhibits 8 through 14, 17, 19 through 22, and Replacement Exhibit 23. Do you have those exhibits in front of you?
Yes.
And those are those all official business records of Ovintiv?
Yes.
Okay, turning your attention to Exhibits 8 through 14, 17, and 19, what are those documents?
Exhibits 8 through 14, 17, and 19 are the notices of opportunity to lease or participate for the Colorado well. And exhibits 20 through 22 were attached to each of these notices.
Okay, and just for the record, what is Exhibit 20?
Exhibit 20 is the survey plat for the Colorado that went out with each of the notice of opportunity to participate or lease.
And what was Exhibit 22?
Exhibit 22 is the AFE that was sent with each of the notices. Mr. Wall will testify as to the actual costs invoiced and incurred.
Again, just for the board's reference, each notice with the reference attachment reflect compliance with the regulatory requirements under R649-1-1 and R649-28A. Now, Mr. Burns, would you please identify the parties being compulsory pooled and their respective gross working interest in this drilling unit?
Yeah, so each of the parties to be pooled are the heirs or devisees of Ida Zeller, who owns 1.030269%, Colt Huber, 0.005495%, Elizabeth E. Jackman, 0.015296%, Kate S. Fowler Markham, 0.004436%, Loretta Huber, 0.000687%, Lynn Huber, 0.006182%, Mary Ellen Sleemaker Binion, 0.031498%, Shelley Smith, aka Shelley No, 0.005915%, Tracy Lee Sherrill, 0.002218%, and Uinta Mineral Holdings LLC, 0.008872%. And in total, this amounts to 1.110868%, which equates to roughly 14.37 net acres.
All right. Again, in the interest of brevity, I'm going to refer the board and the division to the list of decedents that's in the request for agency action. I won't ask you to read all their names. I do want to point out the heirs or devisees of Ida Zeller. You have not been able to identify any of them. Is that correct?
Correct. We have not.
All right. With respect to the other decedents, please identify to the board what has Ovintiv done with them and what's their status.
As Mr. McDonald mentioned, there are several lessors claim title in these lands through one of the more of estates that have not been in either no Utah probate of the estates has been initiated, or if it's been filed, they are incomplete, and that there has been no proper distribution made to the heirs or devisees. And although based on heirship affidavits and other inquiries and research done by our lease broker, and except for the specific parties previously identified to be compulsory pooled and declared as non-consenting owners, we believe we or the other voluntarily pooled working interest owners have leased all of the successors. However, without an order from the Utah courts confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Ovintiv seeks to compulsory pool their interests.
All right. I refer the board and the division to Replacement Exhibit 23, which is the proof of publication to those unknown parties. Mr. Burns, did you receive any responses to the published notice?
We have not.
All right. Now I'm going to turn your attention to Exhibit 22, which was also Exhibit A to the request for agency action. Please identify what that document is.
Yes, Exhibit 22 is the proposed JOA for this compulsory pooling. This form is utilized as a standard industry form supplied by the AAPL. This is Form 610, the 1989 version with modifications to address horizontal wells. This exhibit is materially the same Form JOA sent with mailed notices of opportunity to lease or participate. Terms and conditions contained herein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including those signed by Otter Creek and the other non-operating working interest owners within this DSU. Oventive has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which we are a non-operator, drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
All right, would you please identify some of the relevant terms in the joint operating agreement that are relevant to compulsory pooling?
So page 7 of the JOA addresses the non-consent penalty. And as is standard in this JOA, 100%, 300% non-consent penalty is provided. And then additionally, moving on to Exhibit C of the JOA, this is the COPUS accounting procedure exhibit. Again, this is a standard industry form, almost universally utilized, similar to other JOAs in the Uinta Basin. The two key components here are found on page C3. Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%. This has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses. And then lastly, page C9, this outlines the overhead charges. And in this particular JOA, that's $10,000, $1,000 for the drilling rate, and then the producing rate. The Exhibit A to the JOA will be amended if and once any of the unknowns are ultimately identified and their DSU gross working interests are determined.
Is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by the other working interest owners in this drilling unit and with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right, now turning your attention to Exhibit 24. This is a 4-page exhibit. I'm going to show you the last page on the PowerPoint. Was this prepared by you or Ovintiv personnel with your review?
Yes.
All right, please explain what it shows.
So this is the average weighted royalty calculation exhibit. And this calculation reflects the average weighted landowner's royalty as of the date of spud of the Colorado well. In this particular calculation, we come up with 18.930074%. And again, this does not include any Indian royalty per statute, but does account for royalty under the signed JOAs.
What's the current payout status of this well?
It has reached 100% payout, but has not reached 300% payout.
All right, would you also confirm for the record then all other land-related allegations of the request?
Yes.
Okay, now turning your attention to the certificate of service. Do you have that document in front of you?
Yes, I do.
All right, that's a pleading prepared by my office already on file in this cause. Again, would you please, for the record, identify who are those persons and how are their names and addresses determined?
Yes, the owners shown are all of the production interest owners within the DSU. The addresses are derived from title opinions effective as of November 17th, 2023, as updated by a search of the BIA, BLM, and county records by Lone Wolf Energy, our lease broker, and along with Oventiv's internal records. Copy of the RAA and the certificate of service was also sent to the tribe, UDC, the Vernal Field Office of the BLM, and the BIA.
Madam Chair, with that concludes my examination. Mr. Burns.
Thank you. Division?
We have no questions. Thank you.
Board? Mr. Moon?
So explain Oventiv's listing on the weighted average royalty sheet here, the one that's up right now.
So that's a situation where Oventiv owns unleased minerals, and this, this is a little bit interesting because we are the operator, but if we were to, resign as operator and non-consent future wells, we would be subject to the lease that is part of the JOA, and the royalty provided in that JOA is included here in the calculation.
Interesting.
Mr. Church.
Mr. Burns, just looking at the timing of this well, first production was 6 years ago. 5 years later, these offers to lease were sent out in 2023, and now you're asking for a pooling 6 years later. Is this normal in your operations out there, or is this a unique time frame on this well?
Well, I mean, as we saw on the last hearing, we are a little behind on getting notices of opportunity to participate from as it relates to the spud date of these wells, but we are trying to catch up and give a notice to all owners, giving them an opportunity to lease or participate. We'll say that the title out here is very difficult. There's a lot of unprobated estates where we're searching for months and months, and in some cases years, trying to identify all of these owners. And this Colorado unit is here on the docket today because we've finally completed all of that airship research and been able to more or less conclusively say that we've exhausted all avenues of trying to identify heirs and give them notice.
Okay, so this is more or less a normal time frame in the basin right now because of all the complicated identifying heirs to the different probates.
Yeah, I mean, it is for us. We are working very, very diligently to get all of these owners notice as quickly as we can.
Okay, thank you.
Do we have any other questions? Okay, moving on, Mr. McDonald.
Okay, Mr. Wall, would you please state your name and business address for the record?
Yes, Christopher Wall, business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380. And I'm a reservoir engineering advisor with jurisdiction over this development as well as others in the Uinta Basin.
Turning your attention to Exhibit 25, which is shown on the PowerPoint, was this prepared by you or Uinta personnel with your review and input?
Yes.
All right, would you please explain what it shows?
This Exhibit 25 is a summary of the actual cost invoice to Ovintiv and incurred in drilling, completing, and operating costs for the Colorado well through April 30th, 2024.
And were these figures within reasonable variance of the AFEs that were sent for the well?
Yes.
All right, in your expert opinion, were these costs fair, reasonable, and necessarily incurred, and was the well deemed economically feasible, as that term is used in the 139-150 order?
Yes.
All right, would you please identify for the record what is the estimated plugging and abandonment cost for this well?
Plugging and abandonment cost is $75,000, which is consistent with Uinta Basin P&A costs charged to and by Ovintiv, based on 100% working interest ownership.
All right, now turning your attention to Exhibits 26 and 27, were these prepared by you or Ovinta personnel with your review and input?
Yes.
Turning your attention to Exhibit 26, will you please explain what this shows?
Exhibit 26 is a plat of all the nearby existing horizontal development at the time the Colorado well was spud. And this was the first well in the DSU. And being such, there is really minimal well control.
Now turning your attention to Exhibit 27, again, would you please explain what this shows and its significance to this hearing?
Exhibit 27 is the summary of all the risks. And on the geologic side, we just mentioned this, but there were some geosteering challenges due to the lack of well control. On the drilling and operational side, we have capital cost expectation due to the lack of well control, shallow hazards with artesian water flows. The Uteland Butte interval has high clay content and has the potential to collapse and stick drill pipe and casing. Some recent examples are the Black Hair 7H and the Bruce 42H, where the casing collapsed during completions. On the Tomlin 46H, we had cementing challenges resulting in a loss of the lateral there. And then the sheared BHA on the Abbott 46H is another example of some of the operational challenges that Ovintiv encounters. On the commercial side, there's future oil price uncertainty as well as marketing uncertainty with refinery and rail availability and capacities. The Colorado well in particular did not have any operational challenges during the drilling and completion phase.
All right, is it your expert opinion then, for these reasons, a 300% risk assessment award is therefore justified?
Yes.
Would you also, for the record, confirm all of the other engineering-related allegations of the request for agency action?
Yes.
Madam Chair, that concludes my examination of Mr. Wall.
Thank you. Division.
We have no questions.
Board, do we have any questions? Seeing no questions, back to you, Mr. McDonald.
Thank you, Madam Chair, and bear with me, and I'm going to need you with this. Some of these exhibits were not submitted, even though they were originally filed, because of the acquisitions and the leasing that was done. So I'll try to do this very slowly.
Go slowly.
Okay, Exhibit 1 is supplemented. Exhibits 2 through 6. Updated Exhibit 7. Exhibits 8 through 14. Exhibit 17. Exhibit 19 through 22. Replacement Exhibit 23. And Exhibits 24 through 27 and 28 as supplemented.
Okay, so you are not submitting 15, 16, or 21. Is that correct?
No, 21 we are.
21 you are.
15, 16, and 18 and 19 are not being, or 18 is not being submitted.
18 is not
Yeah.
being submitted. Okay. Division.
No objection.
Board. Admitted.
Thank you, Madam Chair. With that, again, the statutory and regulatory requirements have been satisfied. We believe we've met our burden. Just to address Mr. Church's issue, they're also trying to catch up. That's why you have so many compulsory pooling matters coming in front of you. But going forward, you'll see that more of these wells are the more recent wells as they're drilled in compulsory pooling. And so they're trying to catch up with all that. So two of these matters today were older wells simply trying to catch up and conform with what was done. So.
And so do you still have a backlog that you're going to be bringing to
Yes, there'll be quite a few more
Okay.
through the rest of the year.
Okay, thank you.
All right.
Division.
Thank you, Madam Chair. The division has carefully reviewed the exhibits and the materials submitted, and after the presentation of evidence today, has no objection to granting this request.
Thank you. Board, do you have any questions for this? Seeing no questions, back to you, Mr. McDonald.
Thank you for the board for your patience with these matters. I know they get repetitious and all that, but we need to get them done to get it done properly. Also, thank you for the opportunity to have the witnesses appear virtually, and again, a shout out to the IT people for making it very smoothly. Thank you.
Thank you. Okay, I believe we're ready for a motion.
I'll move that we accept or approve this request for agency action.
I second.
Thank you. It's been moved and seconded. All approving, please say aye.
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 Any opposed? Please show that it was unanimous. Thank you, Mr. McDonald. Would
Yes,
you
and I'll be
please
happy to prepare the order too.
prepare the
Thank you.
order? Thank you. Now, we have one matter left. Are you doing that one also, Mr. McDonald? Do you want to just join the board here? You're a regular participant.
That'd be a conflict of interest.
So it's 10 after. We can have lunch and do one more, or we can do one more and call it adjourned. Okay. All right.
Ready to stand up.
We are going to do lunch, and we will see you back in 5, 10, 15, 20, 25, 30, 35, 40, about 10 to 1, 40 minutes. Thank you. We are off the record. Good afternoon. We are back here after lunch. We are on the record, and we are going to proceed with our last item of the day. Docket number 2024-033, cause number 130-33. In the matter of the request for agency action of Uinta Wax Operating LLC for an order partially modifying the board's order entered in cause number 130-12 to 1, reorient drilling units from stand-up or vertical to lay-down horizontal for sections 15 through 22, 4 South, 4 West, USM, and 2, reorient the authorized drilling unit boundary wells in the drilling units, therefore, comprised of sections 15, 16, 21, and 22, 17 South through 20, 4 South, 4 West, USM, and sections 18 and 19, Township 4 South, 4 West, USM, sections 13 and 24, 4 South, 5 West, USM, from stand-up to lay-down, and 3, establish uniform boundary setbacks of 330 feet, therefore, all in Uinta County, Utah. Mr. McDonald.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Uinta Wax Operating LLC.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Mr. McDonald.
Thank you, Madam Chair. I want to make sure one of my witnesses is available. I still don't see him on the screen yet. Robbie's not on the screen yet.
Okay.
I did text him, asked him to get on.
I can go poke my head in his office real quick.
Okay, thanks, Taylor.
Hey, I'm here. I'm sorry, I'm having
Okay,
a
all
little
right,
technical
good.
issue.
Thank you. Okay.
Right.
Thank you, Madam Chair.
Thank you.
With me today, appearing virtually again, thank you to the board for pursuant to its June 12th order, are Mr. Zachary Archer, the senior landman of Uinta Wax LLC. Zach, you want to wave so they can see who you are? Thank you. Mr. Robbie Horner, the senior geologist of Uinta Wax LLC, and Mr. Taylor Cotton, the reservoir engineer of Uinta Wax LLC. All three of them share duties with the petitioner as well. I would ask that they be sworn in at this time.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Members of the board, the resume of all three witnesses were collectively submitted as Exhibit A in this matter. If asked, each would confirm the information reflected in their respective resume as true and correct. Mr. Archer will be a fact witness only. Mr. Horner and Mr. Taylor have been previously recognized by the board as experts in geology and reservoir engineering, respectively. Based on their resumes and their previous resignation, and presuming the division has no objection, we again request that they be recognized as experts in those respective disciplines for purposes of this cause.
Division?
Yeah, no objections.
Board? So accepted.
Thank you. And again, I will be moving for admission of the exhibits at the end of my presentation in chief.
Thank you.
Members of the board, Uinta Wax is before you today seeking to reorient 4 adjacent stand-up drilling units in Township 4 South, Range 4 West, as established under the board's order entered in 130-12 to lay-down orientation. Uinta Wax is consequently also requesting reorientation of the drilling unit boundary well drilling units established under that order from stand-up to lay-down as well. Finally, Uinta Wax is requesting uniform 330-foot setbacks from the boundaries be established. As was addressed in the testimony in the 130-12 hearing and in finding number 12 of that order, in the western portion of the Uinta Basin, the interpreted regional stress is transitional. At the time the 130-12 order was entered, Uinta Wax believed a stand-up orientation would result in perpendicular intersection with fractures, especially given the Duchesne fault. However, as the testimony provided today will reflect, data obtained from wells drilled in nearby areas since the 130-12 order was entered suggests a laydown orientation may in fact result in a more prolific production. Uinta Wax requests uniform 330-foot setbacks for the reoriented drilling units for consistency between the adjacent and reoriented drilling unit setbacks. Similar relief was sought and granted by the board earlier this year for adjacent lands in Township 4 South, Range 5 West, in cause number 130-26. True and correct copies of the 130-12 and 130-26 orders were collectively submitted as Exhibit B in this matter. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners in the subject drilling units and to all working interest owners, including unleased interest owners, in the established drilling units adjacent to the subject drilling units, and to the Ute Tribe, UDC, Bureau of Indian Affairs, and Vernal Field Office of the BLM as the technical advisor to the BIA due to Indian ownership. The mailings were sent to these parties at their last addresses disclosed by the relevant Duchesne County and BIA realty records and Uinta-Wax's internal land records. The record will also reflect that notice was duly published in the Salt Lake Tribune on June 2nd, 2024, in the Uinta Basin Standard on June 5th, 2024, and in the Deseret News on June 7th, 2024. On June 10th, 2024, the division timely filed a response stating that the division does not oppose the granting of the relief requested, presuming that Uinta-Wax satisfies its burden of proof at this hearing. As today's testimony will reflect, Uinta-Wax will sustain that burden. This past Monday, WEM Operating LLC filed a letter in support of the granting of the request for agency action, but also recommended 100-foot heel-toe setbacks instead of 330-foot setbacks. Mr. Cotton will address why Uinta-Wax believes 330-foot heel-toe setbacks have instead been requested. No other objections or responses were received. With that, I'll commence my examination of Mr. Archer. Mr. Archer, would you please state your name and business address for the record?
Zachary Archer, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what's your current position with Uinta-Wax Operating?
I'm a senior landman for Uinta-Wax, and my area of responsibility is the lands in question.
All right, would you please state for the record the corporate and bonding status of Uinta-Wax Operating?
Uinta-Wax Operating is a Delaware limited liability corporation in good standing with its principal place of business in Fort Worth, Texas. Uinta-Wax is duly authorized to conduct business in the state of Utah and is fully bonded with all the relevant state of Utah and federal agencies. It is the designated operator on behalf of Uinta-Wax LLC.
I'm going to direct your attention to what have been marked as Exhibits C through G for purposes of this cause. They're shown on the PowerPoint. Do you recognize these exhibits?
Yes, sir.
Were they prepared by you or Uinta-Wax personnel with your review and input?
Yes, sir.
Starting with Exhibit C, would you please explain what this shows to the board and division?
So this is a regional locator map. These are the lands that are included in the requested RAA and are located about approximately 2 miles due southeast of the city of Duchesne.
Now, turning your attention to Exhibit D, this is a 2-page exhibit. Starting with Exhibit D1, would you please explain what this shows?
So D1 is the application lands. They're in the current orientation of stand-up DSUs established under the 130-12 order.
And turning to D2?
D2 is the lands in question, but they are the proposed reoriented DSUs to laydowns.
All right. What is the nature of the oil and gas ownership in these drilling units?
The ownership is tribal, with the remainder being fee.
All right. And does Uinta-Wax LLC, is it the majority working interest owner in these drilling units?
Yes, Uinta-Wax is the majority working interest in the requested DSUs.
All right. Now, turning your attention to Exhibit E, would you please explain what this shows to the board and division?
So this is the 2560 overlapping DSUs or drilling unit boundary well DSUs as established under the 130-12 order. What we're seeking here is to reorient the underlying DSUs from stand-up to laydown. The authorized drilling unit boundary well DSU wells likewise require reorientation from north, south to east, west. And again, in these lands, Uinta-Wax is the majority working interest owner in the drilling unit boundary well DSUs.
Now turning attention to Exhibit F, please explain what this shows to the board and division.
So Exhibit F are all the exhibit wells. They're located in the requested reoriented lands. There's 3 wells. You've got the Duchesne Ute Tribal 3, the Duchesne Ute Tribal 5, which are both in Section 16 and are both currently shut in. And you have the Ute Tribal 4, 18D in Section 18, which is also shut in.
What is the, yeah, go ahead.
I was going to say, since the 130 order only applies to long lateral horizontal wells, the production allocation from the existing wells will be unaffected by the requested reorientations. It'll remain on a wellbore allocation basis under the rule of capture. And no long lateral horizontal wells have yet to be drilled or authorized under the 13012 that were authorized under the 13012 order.
Now turning your attention to Exhibit G, would you please explain what this shows?
So this is the plat reflecting the areas that were notified for this requested reorientation. It's all the production interest owners within the subject lands. All working interest owners in all the adjacent drilling units were additionally notified.
All right, turning your attention then to the certificate and supplemental certificates of service. Do you have those in front of you?
Yes, I do.
All right, these are pleadings that were prepared by my office and are on file in this cause. Do you recognize the parties and the addresses shown there, and how were they compiled?
Yes, sir. I do recognize them. They were compiled from Uinta Wax Operating and Uinta Wax LLC's internal land records, including title opinions and searches of the Duchesne County records and BIA records prior to the filing of the RA requested by Uinta Wax Operating, and through contracted land services as well.
Okay, and so those were the parties that, as you reflected on Exhibit G, is that correct?
Yes, sir.
All right. Madam Chair, that concludes my examination of Mr. Archer.
Division.
I just have a question about Exhibit E, overlapping 2560s. Are we just concerned with the 2 here? I believe in the request for agency action, there was mention of another 2560, including sections 18, 19, and then is it 13 and 24? Just clarify.
13 and 24, we wouldn't. Go ahead, Fred.
No, I was just going to say it's just these.
It's just these 2. Yes. Okay, the request did have a 3rd one in there, but if it's just the 2.
It wasn't intended.
Okay.
It's these two 2560s that were established under that, and all we're doing is changing the drilling unit boundary well from north-south as was established east-west.
Okay, that's great. Thanks for that clarification. I saw that. Yeah, no further questions from the division.
Board. Are those vertical wells going to remain on individual well production until they're plugged?
Yes, there
will be no
there's no conversion in this one. In other words, yes.
Thank you. Board. Okay.
Thank you. With that, I'll commence my examination. Mr. Horner. Mr. Horner, would you please state your name and business address for the record?
My name is Robbie Horner. I'm located at 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107. And my title here is a senior geologist with Uinta Wax.
And you're working this area?
Yes, sir.
Okay. Turning your attention to what has been marked as Exhibit H. Did you prepare this, or were you was it prepared by Uinta Wax personnel with your review and input?
Sir.
Okay. Would you please explain to the board and division what this shows?
This is interpreted regional stress regimes across the area of interest. And it shows that there's tropic stresses that are north 45 west in the proposed units.
All right. And it was Uinta Wax's original position that maybe a north-south orientation would be better in this area?
Yes, and as Mr. Cotton will address, the wells that have been north-south versus east-west have different production profiles.
Okay. Is it your expert opinion then that the revised geologic analysis and needed testing supports reorientation from stand-up to lay-down?
Yes.
Based on this, okay. And then from a geologic standpoint, the requested relief will confirm the orientation for this area and therefore allow for greater recovery of natural resources.
I believe so, yes.
Okay. That concludes my examination of Mr. Horner.
Division, do you have questions?
Peter Pankey with the division would like to ask a question.
Thank you.
Hi, Peter Pankey with the division. I love asking this question. I just want to know, so there's a lot of data on here. I'm just curious if you know where these data came from and if they're from logs or from seismic or where you got these orientations from.
Yeah, we have a number of different data sources, and I believe as it pertains to this data set, these are dipulsonic as well as microseismic data points.
Perfect. And then I can see the Duchesne fault zone runs through there. Is there any significance to that?
The reservoir level, it has been argued that it does not, and we also believe that it does not, and it's more of a superficial fault system.
Perfect. No further questions. Thanks.
That's all from the division. Thank you.
Board, do you have questions? Mr. McDonald.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Cotton. Mr. Cotton, would you please state your name and business address for the record?
Taylor Cotton and 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what's your current position with Uinta Wax and Uinta Wax Operating?
The reservoir engineer for the Uinta Basin.
And you work this particular area, is that correct?
That's correct.
Okay, turning your attention to Exhibit I. Was this exhibit prepared by you or Uinta Wax personnel with your review and input?
Yes, it was prepared by me.
Okay, would you please explain the significance of this and what it means in relation to the request?
Yeah, so this shows the results from nearby wells with offsetting differing orientations. And the plot shows the normalized cumulative oil production for a 4-well pad that was drilled as laydowns and then a 2-well pad that was drilled as stand-ups. And the colors on the plot tied to the colors on the map. And the results suggest that laydown orientation should result in more prolific production.
And this data was generated after the 13012 order was entered? Is that correct?
That's correct.
All right, thank you. Could you please address why Uinta Wax is asking for a 330-foot uniform boundary setback instead of the 100 that WEM has suggested?
Yes, so the 330-foot setbacks are consistent with what we previously requested in the lands to the west. And we believe that at this time, it's the prudent approach for the development of this transition area.
All right, is it your expert opinion then that the analysis of data from nearby wells with offsetting different orientations support reorientation of the subject lands from stand-up to laydown?
Yes.
Is it also your expert opinion that the requested relief should allow for the greatest recovery of natural resources with associated greater economic benefit with no or minimal adverse impact on adjacent correlative rights?
Yes.
All right, Madam Chair, that concludes my examination of Mr. Cotton.
Division, do you have questions?
Yes, the division does have some questions from division staff.
Yeah, Peter Pankey again with the division. So I just want to help me understand. In January, it was Ovintiv that brought its docket 2024-004 cause 130-27. They brought this cause and argued that they were doing the same thing you were doing, taking stand-ups and going to laydowns. And we talked all about it, but I believe it was Uinta Wax that was there and opposed Ovintiv doing this. And I'm just curious, what has changed since then? And these lands were just to the east in 4 South, 4 West, actually, where those two, in the image we're looking at, where those two, I believe it's the Alice and the Can't remember.
We protested the setback distance. We didn't protest that they were laying the units down.
Oh, okay. Sorry. I must have misunderstood. But that
Yeah, at that same hearing, we laid down the two DSUs that are immediately to the west of this.
Yeah, sorry, I misunderstood. I thought that I remembered it differently, but obviously you know what's right. So thank you for putting that to rest for me.
Mr. McDonald, going back to the heading for this matter, you also include sections 13 and 24 of 4 South 5 West, but those lands are not.
They are not part of this. Yeah, it's just 15 through 22.
So
I apologize for that if that
This
was.
hearing does not include 13 and 24 of 4 South 5 West.
Correct.
Okay, thank you. Questions? Mr. Moon?
Yeah, going along with what was just asked by the division. What are the setbacks in Oventive's 1423 just to your east there? Aren't they 100-foot setbacks there, Hill-Toe?
I can't speak to what Oventive's setbacks are.
I think everything's pretty much been 100. So they're going to come within 100 foot of you, but you're saying we're going to voluntarily stay back 330 feet from Oventive. How there? Yeah, the closer you get to the section line, there's more risk of eventually draining something on the other side of the section line, but. The other big risk, well, it's almost how, if you leave oil and gas there, how would you ever access it? Because you have two wells coming together, they're east-west wells, laydowns. How would you ever recover that oil if you're only reaching out, say, 100 feet?
We didn't say that we were reaching out 100 feet.
Well, I guess my question.
Yeah,
is,
I guess I don't understand what the question is.
Perhaps I can help.
The data we have, we think it's 300, so that would drain effectively.
The problem is you've got two different operators, and so they would have to come agreement for any kind of boundary well agreement there. And right, what I think Mr. Cotton has stated is Uinta-Wax's position is 330 is more justified at this point to protect correlative rights.
Okay. And that's because of the transition, because you feel like you're reaching further because it's transition. Okay.
Mr. Church?
Yes. Mr. Horner, I wanted to understand Exhibit I. When you list the cumulative oil production, 24 months, are you saying this is the first 24 months for each of these wells? Or is it the last 24 months? I'm trying to understand the label of what the production is.
The first and the only 24 months.
Okay, so this is the total cumulative production. And you're saying that all of the wells have only produced for 24 months?
On those 6 pads, I believe so.
Okay, but also, does that apply to the Phillip and the Alice wells, the two vertical wells to the east, or the stand-up wells, pardon me? So I'm trying to compare.
Longer. I think they were on 2 months before the moon, but the volumes are 24-month volumes.
They're so the first 24 months. So all of these wells were trying to compare the stand-up with the laydowns, and I wanted to make sure we were using the same parameters for all of these wells. So they've all had this same.
The first 24 months.
The first 24 months. Okay. Because I remember when we were talking about originally getting the order for making these stand-ups, it was to intersect vertically or at right angles coming down through the Duchesne Fault Zone. And now we're saying because of those wells out to the east, we're saying maybe that just didn't work out. And you're saying you think it's a vertical expression of or a surface expression of the faults. I know seismic indicates these faults go to some depth, so it's the timing on these. I just feel like there's a little bit of piousity of data on geologically trying to understand this. When we look at the equal stresses in the 2 wells southwest of this block, they're equal, which means that there's not a preferred direction that you'd want to drill through those, whether you did them stand up or lay down. So I'm really trying to, this is kind of a no man's land in between those equal stress wells in the Utland Butte and the wells north of there. But you're basing this principally on the Phillip and the Alice wells as being not the kind of production that you're wanting to get.
That's correct.
Okay, so no other wells to the south or to the west, then it's those 2 wells to the east. Just wanted to understand the logic on this whole block through here, on what you're basing your information on.
This is the closest offset production to the lands at question.
Okay. I just need to think about that, but thanks for those that answer.
Mr. Walker?
Yes, I would like to understand Exhibit I a little better also. Now, on the top graph, you've got 4 production lines there. Are the traces of the horizontal wells that are in sections 1, 2, 5, 6, 7, 8, 11, and 12, are they related to those 4 wells up on the top, the production lines?
I haven't seen production on those as well, so south of there.
Okay, so those blue arrows, are they related to the top graph at all?
Yes, the color, the blue lines on the plot tied to the blue arrows on the map.
Okay, and then the orange arrows, are they also related to the orange arrows on the plot?
Yes.
So the 2 other wells are also horizontal wells, the ones going through 15 and 24 and 16 and 19? We've got those labeled as stand-ups.
15 and
24.
The wells in 15 and 24.
Okay,
13 and 24.
Okay, they go through 13 and 24 and 18 and 19.
It's the Phillip and Alice wells.
Okay, so
Yeah, the stand-up.
those are horizontal wells?
Yes.
Yes.
Okay. So all of these, then, you're talking about all 6 of these wells that are indicated down there are horizontal wells, and you're comparing horizontal well production to horizontal well production.
That's correct.
4 lay down horizontals and 2 are stand up horizontals.
Okay.
Just,
Mr. Church?
Also, Mr. Horner, are these all out of the Utland Butte, or are they out of different productive horizons?
They're all out of the Utland Butte.
Okay, thank you.
Mr. Walker?
Yeah, okay. Now, you're planning to stimulate the wells that you're going to drill in Forth South and Forth West? And are you forecasting what your half lengths of the fracs are going to be?
We don't have a lot of nearby data, but we think it's going to be closer to the 300.
Okay.
Board, we have any further questions? We are back to Mr. McDonald.
Thank you, Madam Chair. That concludes our presentation in chief. First, I'm going to move for admission of exhibits A through I inclusive.
Division, are you?
Yep, no objections.
Board, are you okay with the exhibits? So admitted.
Thank you. You know, I understand a little bit of the questions here. As you know, this is a strange area, and they're still testing all this out, and that part of the reason why some of the operators are saying one thing and the other operators are saying another. Part of the idea here is based now on what they've learned to date. They believe a lay-down orientation may be better than the stand-up, and part of the reason for this is to test this as well and make sure that that is in fact the case. So it's still a learning episode here. There isn't, you know, a lot to hang your hat on until they actually drill. So that's part of why, again, they're asking for the reorientation. And again, the board granted similar relief just to the west of this, adjacent to it. Just want to make that clarification. Other than that, I do believe that, you know, with the removal of 13 and 24 on the drilling unit boundary, and I apologize for that, I believe we've met the burden. There's no opposition, and we would ask that the board grant the request as stated, and I'll reserve any closing remarks after the division.
Division.
Thank you. Yes, the division does not have opposition to this request as it's being presented here today. So we're in support of it.
Thank you. Board, do you have any further questions? Mr. Moon.
Yeah, just a comment that, and it's kind of stating the obvious, but you know, after the first wells are drilled and there's more data, I guess there's no way we could put in an order that if test results show that a shorter setback or a smaller setback is justified, adjust it. I guess you have to come back and request again to go to 100.
Well, I think if the data shows that they can get that close, they would want to do that for any additional wells. That's been the trend.
Yeah, and have we ever done an order where the heel? Well, you're going both directions here. So I'd say the further east you go, the more likely, you know, you're not going to reach that 330 feet. You know, where you're in the center and going left, I think that transition zone somewhere there. But they're basically you're basically requesting 330, both directions, heel and toe. Is that correct?
Correct.
Okay.
It's uniform across both perpendicular and heel and toe.
Okay, because that's even putting a 330-foot setback right in the center of these drilling units, which is all wax. So, okay. Okay, so yeah, this would be my comment. Come back with when there's more data. And
I think that's the
shorten
idea.
those up because it's pretty hard to go back and get it. So,
Board, do you have any other questions? Mr. McDonald.
Again, thank you, board, for allowing the witnesses to testify. I know it's been a long day. Appreciate your attention. And again, a shout out to the IT people for making it go smoothly. Thank you.
Okay. Are we ready to approve it, or do we need to deliberate?
I'll make a motion.
Please.
I move that we approve the RAA as requested.
I'll second that.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Motion carries unanimously. Thank you.
Thank you.
Please prepare the order, Mr. McDonald.
Certainly.
And with that, oh, Mr. McDonald, we need to exclude sections.
Yes, sections 13 and 24. I'll make sure that's in the
excluded?
order, yes.
Thank
And I'll work with board and division council on that.
Thank you. Do I have a motion to adjourn? I believe we are finished.
I move we adjourn.
Adjourned. Thank you. We are off the record.